Well, if not, members, we have a lengthy calendar tonight. We have a time constraint of 2 hours, so at 7 p.m. we will be conducting a hard stop. I know that there are a lot of folks here that have traveled many miles to testify. We're going to try to get to every piece of legislation that has someone with testimony on that today. We may not take any final action on that legislation today because of time restraints, but we will give as best as possible an opportunity for those that are here to testify before this committee. With that being said, we will, first bill on our calendar is House Bill 52 by Speaker Pro Tem Marsh. We have a motion and a second. Speaker Marsh, you are recognized.
Thank you, Mr. Chairman and committee. This bill is one we had up last year that was passed on the House floor and got hung up in the pandemic, and we're starting over again. But it is the bill about antique slot machines. And this bill is trying to say it is not an offense for a person to own, possess, buy, or sell an antique coin machine, and antique means over 25 years old, if the antique coin machine is not used for gambling purposes. Any person selling an antique coin machine shall indicate to all prospective buyers that the antique coin machine is not to be used for gambling. And if this bill passes, it would allow antique stores and auction houses to legally display and sell vintage gambling machines. With the new law change, perhaps more sales could happen, which means more sales tax revenue. It allows for large auction houses to hold auctions in the state. Auction houses like Morphy Auctions regularly pull in $2 to $3 million per auction sales on vintage gambling machines. We're hoping if we pass this law that we can compete with other cities across the nation to bring one of these big shows to Nashville or Memphis or Knoxville, some of the bigger cities in the state. So with that, I'll answer any questions.
Thank you. Members, are there any questions for the sponsor, Representative Griffey?
Thank you, Mr. Chairman. Thank you, Speaker, for bringing this the bill, and I wanted to commend you for circulating those photographs of examples of these antique gambling machines. Is there a distinction in the bill for electronic versus electrified or non-electrified?
I think it's just antique, older than 25 years.
Okay. Thank you. That's all I have.
And today I have a constituent of mine, Rick Akers, called me a couple of years ago and told me about this problem. I didn't know that they were illegal, and I didn't know Mr. Akers, and went out to view his slot machines and found out that he was illegal, but I didn't know that. Nobody else, sheriff, nobody knew it. But with this bill today, we're going to make it where he can buy and swap and sell antique slot, gambling machines without breaking the law. So I'm proud to represent one of my constituents today.
Well, very good. Any other questions for the sponsor? We've got some that are here to testify on this. Representative Hardaway, do you have a question?
Sir, I'll wait until the testimony is over.
Okay, thank you. Without objection, we'll go out of session to hear from.
Do you want to go?
From our.
He doesn't have to talk. We're okay without that. Unless you just.
Well, I've got others on the list. You need some? Okay, well, we'll go out of session right quick and come back. We'll go out of session. Skip Armistead, if you're here, you're listed to speak. If you will come, you can access the microphone at the table. There'll be a microphone there for you to use, a button. If you will press that button, introduce yourself, and then you have testimony that had been sent out to all the members of this committee ahead of time, but you'll have 4 minutes for your testimony, and then we'll have time for questions from the members if they choose.
Thank you, Representatives. I appreciate the opportunity to speak. I am Charles Armistead. I go by Skip. I'm a very concerned citizen. On January 5th, I emailed Representative Marsh asking these particular questions about this bill. I asked, would this bill allow me to purchase gambling devices and create a casino-type museum as long as I didn't let people gamble with real money? Could I allow visitors to have hands-on experience allowing them to play the machines using fake coins. Could I charge for such an experience? Well, Representative Marsh then forwarded that email to Mr. Akers, the kind gentleman who's encouraging Representative Marsh to sponsor this bill. Mr. Akers emailed me later that day saying, "I like your idea of opening a casino-type museum. If you'd like to talk about it, I'd love to." Immediately, I knew I'd spotted a loophole in this bill that would allow the gambling industry to exploit. So I called Mr. Akers, and we had a lengthy, delightful conversation. He's a delightful man. And he was very clear that he opposes gambling of any form and just wanted to collect antique gambling devices for his collection. I explained that while I didn't oppose people owning such devices, I wanted to plug a loophole in the bill that can be exploited by the gambling industry, and that the possibility of a museum is such a loophole, especially if people have to play to access the gambling devices. Then I called Dr. John Kent, who is professor of business administration at the University of Illinois, an expert in economics of gambling. Also is published at Vanderbilt Law School. He said that even though the sponsor only wants to collect gambling devices, the gambling industry can jump all over this loophole, create gambling casino-type museums and other displays as a means to get people to gamble and as a step towards casino gambling. He says that this is the type of legislation that has already led to exploitation in Nevada, Colorado, Texas, and the state of Illinois. In fact, Dr. Kent points to the 6 volumes of the International Gambling Report published by the University of Illinois, which says the gambling industry uses this type of legislation to lure states and individuals into gambling. Next, I contacted Mr. Les Banal, the director of Stop Predatory Gambling. He says that the Native American tribes can jump on this bills like this to create their museums and displays as a step towards casino and other forms of gambling on their reservations. Both Dr. Kent and Mr. Banal were adamant that legislation like this, which seems so innocent, creates the greatest leverage for the gambling industry to exploit. So I recommend to add the following words to the bill. No individual, group, or business may publicly display or allow the use of gambling devices in any way other than having them as personal collectibles. Government-sponsored museums may display these devices only on their museum locations. The amendment still allows the auctions, still allows Mr. Akers to get his devices. It just plugs the loophole to prevent the gambling industry from exploiting it. Also, as a minor thing, the antiques experts say that the definition of antique is 100 years or older. Something that is 25 years old is called vintage. So to be grammatically correct, I suggest the committee replace the word antique with the word vintage. Do you have any questions? I'm not opposed to the bill. I'm opposed to not plugging the loophole in the bill.
Thank you. Do any members have any questions? Chairman Farmer?
Thank you, Chairman Doggett. I appreciate that. And thank you for that, sir. I'm just curious if you've approached your representative and/or senator about maybe putting a bill in that does this and not trying to amend Chairman Marsh's bill.
An additional bill?
Yes.
No, I haven't, because I didn't see a need to, because this is the bill that opens it up. This is what the gambling industry wants. And so to plug the hole is this right here. This plugs the hole.
Mr. Chairman?
Yes, sir.
Ma'am? Okay. Well, the Tennessee State Constitution says that games of chance are unconstitutional.
Oh, yeah.
Okay.
I understand that.
And I don't see this legislation being an issue here. But back to, and who's your state representative? Who's your representative?
Glenn Cassida.
Okay. You may want to talk to Glenn. Maybe he could drop a piece of legislation for here. So I just don't think it's appropriate to be asking the committee to adjust this piece of legislation at this point in time. Thank you.
Representative Gifford?
Thank you, Mr. Chairman. Mr. Armstead, would it be accurate that if we pass this bill, simply possessing the machines, there would be nothing illegal about that? What would become illegal is when someone decides to use these machines, the antique vintage machines, in an illegal manner. Is that
Exactly.
fair to say? Okay. That's all I have, Mr. Chairman. Thank you.
Maybe I haven't explained it correctly. This is the gambling industry's camel's nose under the tent to head the state towards gambling. This is what they did in Nevada. Like I said, Nevada, Colorado, Texas, Illinois. This is the camel's nose. Even though it is illegal, as it was there, this was the beginning point.
Okay. Thank you. Are there any other questions for our guest? Okay, Representative Hardaway.
Thank you, Mr. Chairman, and good afternoon to you, sir. The part of your presentation that dealt with the Native Americans, I thought they had autonomy. So I don't see how, if you could help me understand how his bill would give them any additional advantage.
While they have autonomy, as I understand it, they still have to work with the state. And like in Alabama, they were not allowed to do bingo or any other type thing until the state allowed it. And all of a sudden they had bingo and casinos and all that stuff. So I don't understand that rule, but I understand that by us not having it, it is hard for them to have it.
Okay, but it's my understanding that it would take a federally recognized tribe to have that type of autonomy, and I don't know of a tribe that we have in Tennessee.
We have one up in East Tennessee, and I'll find that rule for you. I'll be glad to get that for you.
I appreciate that. Thank you, Mr. Chairman. Thank you, sir.
Yes, sir. Thank you. Any other questions? If not, thank you, Mr. Armistead, for your testimony and for being here today. You're excused. We have one other, Mr. Rick Akers, if he would like to testify. You'll have 4 minutes. I know you guys are in a hurry. I don't mind skipping it. Okay. All right. Well, then, without objection, we'll go back in session. Question has been called. Any objections? Seeing none, we are now voting on House Bill 52. For all those in favor, say aye. Those opposed, say no. The ayes have it. The bill moves on to full criminal. Thank you. Hey, Ron. All right, members, we are going to jump ahead here for a moment. We're going to go out of order and pick up item number 9 on your calendar, which is House Bill 22 by Representative Gillespie. Representative Gillespie, you can come to the... You have a motion and a second, and you are recognized.
Thank you, Mr. Chairman. Thank you, committee. This is House Bill 22. Basically what it does is it increases the penalties for drag racing on city streets from a Class B misdemeanor to a Class A misdemeanor. And that would increase the jail time to up to a year. And I welcome any questions you'll have, but that's pretty much the gist of it.
Thank you, Representative. Are there any questions for Leader Lamberth? You're recognized.
Thank you, Mr. Chairman. And to the member, I know you were recently elected and elected pretty overwhelmingly, if I remember correctly. Is this your first bill to present in a committee?
Yes, Leader, it does.
Mr. Chairman, when he responded, did he go back to the chair to be recognized?
Leader, he did not. Member, that is etiquette before this committee is to call to the chair for any other comments. Leader Lamberth, you're recognized.
Mr. Chairman, thank you for recognizing me before I spoke. I appreciate that. I would give you a hard time on this, but I actually signed on to this bill because it appears to me to be a very good bill, and I know this is a big issue in your district. So I would joke with you quite a bit and give you a hard time as your first bill, but I'm precluding from doing so because it does appear to remedy an issue in Memphis that has become very dangerous. So I appreciate you bringing the bill. I do hope you have a bill at some juncture that we can give you an extraordinarily hard time on, and it is an honor to serve with you, Representative Gillespie. Those are my comments, Mr. Chairman.
Thank you. Representative Hardaway.
Thank you, Mr. Chairman. To the sponsor, would you be kind enough to relate that main incident in Shelby County that caught our attention?
Mr. Chairman?
Yes, sir.
I believe, Representative Hardaway, you're talking about the incident on 240. So approximately 3 months ago, there was an incident on Interstate 240 where traffic was completely halted in basically all directions, and it came to a standstill. And they were doing donuts and street racing on the entire interstate, halting traffic completely for a good bit of time. And I do not believe any of those people were ever caught. So this would address that if those people were caught.
Representative?
Thank you, Mr. Chairman. And they essentially set up a rolling roadblock and took over the expressways, did their clowning, and then took off, and then the roadblock released. So thank you to the sponsor. Thank you, Mr. Chairman.
Yes, sir. Thank you. Any other questions? Representative Griffey.
Thank you, Mr. Chairman. Thank you, Representative, for bringing this bill in the interest of public safety. I think it's extremely important that we do whatever we can to keep our public safe and our traffic flowing. Thank you.
Chairman Curcio.
Thank you, Mr. Chairman. And to the sponsor, I just want to say, commend you. I know this is an issue that you kind of came to the General Assembly with, and something that maybe was an issue before you were elected. One of the things that we talked about was that a lot of times in the Criminal Justice Committee, we know we're doing something when it has a fiscal impact, right? Because there are criminal penalties that are levied. And one thing I talked about was that this does have a local fiscal impact. And so we had talked, just kind of looking out for you, wanted to make sure that your locals, were aware of that. And would you mind speaking to that?
You recognized.
Yes, that is correct. Thank you for bringing that up. This bill was brought to me by numerous members of both the Memphis City Council, Shelby County Commission, our DA, our police chiefs. So it is very, very much noted that there is a fiscal impact and it will affect them, and they're okay with that because it will keep us safer.
Great. Thank you very much. Thank you for bringing the bill. Thank you, Mr. Chairman.
Thank you. Any other questions for the sponsor? Representative Hardaway.
Thank you, Mr. Chairman. And the police chief would be here to speak on this bill except for traffic issues. Thank you.
Yes. Anything else? Question has been called. Without objection, we are now voting on House Bill 22. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Congratulations. Your bill moves on to full criminal. Thank you very much. We will go back now on our calendar to item number 2 by Leader Gant, House Bill 511. Have a motion and a second. Leader Gant, you are recognized. There is an amendment on this bill. Have a motion and a second. Amendment number 003894. Is that Chairman Curcio?
Thank you for recognizing me, Mr. Chairman, and to the sponsor, thank you for your indulgence. Members, this, and I won't speak for the sponsor, but I will say this is a friendly amendment that Leader Gant and I spoke about earlier, but it fit within the caption. And right now, we have an error in code. Right now, code instructs, or rather demands, that the judge state the jury shall be instructed a defendant who receives a sentence of imprisonment for life shall not be eligible for parole consideration until the defendant has served at least 25 full calendar years of the sentence. That statement that we require the judge to speak is inaccurate, yet they have to utter it anyway because we put it in black letter code. So what my amendment does is simply updates that so that we're not asking our judges to, in essence, deliver incorrect information to a jury. So it changes it to what is correct, which is 51 full calendar years, not 25 full calendar years. So no change in how that process works. It's just what the judge, he or she, has to say to the jury so they understand what they're doing.
Thank you, Chairman. Leader Gant.
Thank you, and I want to thank Chairman Curcio for catching this, and so thank you for that.
Okay. Thank you. Members, we'll now be voting on the amendment, Amendment 003894. To add on to the bill, all those in favor say aye. Aye. Those opposed, no. The ayes have it. It is now on the bill. We are on House Bill 511 as amended. Leader Gant.
Thank you, Mr. Chairman and committee. What this bill does is it creates a mandatory minimum life without parole for the first-degree murder of a first responder. First responders include, and I need to be on record here, first responders include law enforcement officers, correctional officers, Department of Correction employees, probation and parole officers, emergency medical workers, rescue workers, emergency medical technicians, paramedics, or firefighters who are engaged in the performance of official duties. The intent of this bill is to further deter any life-threatening encounters our first responders may face in the line of duty. With the rise of anti-cop rhetoric across the country, we want to continue to provide our first responders with the safest environment possible in an already perilous career. But going back to the original point, all this is doing is creating that mandatory minimum life without parole for the first-degree murder of a first responder. The other option is the death penalty. So they have two options to consider in this case. Mr. Chairman?
Thank you. Any questions for our sponsor? Representative Moody, Chairman Moody.
Thank you, Chairman. It's not really a question, but I want to thank Leader Gant for reading that list. And it's been brought to my attention in my district that the firefighters in the last 2 to 5 years have come under attack with false calls, and then they're using some high-powered powder and canisters and all kinds of things to try to harm them. And so it is truly a need for all our first responders, but thank you for including those firemen. Thank you.
Thank you. Any other questions for our sponsor? Representative Hardaway.
Thank you, Mr. Chairman. And I'm certainly with you on the sentiment for this bill. My one concern is throwing away the life of any individual, and life without parole. I've got an issue with that part of it, if there was a minimum. And maybe there is some type of credits. The way that reads, is it life without parole, period, or is it still possible for credits or somehow to be released? And Mr. Chairman, I don't know whether the sponsor would want legal to respond to that, or if the sponsor wants to.
Mr. Chairman, we can yield to legal, but to my knowledge, there is no other option.
Okay. We'll go out of session here, recognize legal services to answer this question without objection.
Elizabeth and Sonia, Legal Services. The sponsor is correct that life without parole means that there is no chance for parole.
Okay, thank you. We will go back in session to take up Leader Gant.
Mr. Chairman, and that is the exact intent of this legislation. That creates, hopefully, a deterrent here for people to think twice about targeting our first responders here in the state of Tennessee.
Thank you. Any other questions for the sponsor? Vice Chair Sexton.
Thank you, Chairman Doggett. You may have already answered this question. It kind of follows the previous question. How is this different from any other murder? What distinguishes it from just a regular individual?
Well, the code actually, I actually will defer to legal on that because they've got actually that in the code and they can read the disparity in that. We can defer to legal on that.
Without objection, we'll go back out of session to hear from legal.
I think the difference would be the aggravating circumstance in this case would be that the murder was committed against a law enforcement officer, correctional officer, Department of Correction employee, probation and parole officer, emergency medical or rescue worker, emergency medical technician, paramedic, or firefighter who was engaged in the performance of official duties, and the defendant reasonably should have known they were engaged in the performance of official duties.
Thank you.
Do you have any other questions for legal? Or no? Okay, well, we'll go back in session then.
Just like to make a statement, if I could, that while I appreciate what you're doing in the spirit of the law, I do have some concerns when we start creating different classes of people and their importance. I think a convenience store clerk's life is just as important as an officer's, but yet they're performing a public duty, and if someone comes in and murders them while they're there, I think their life is as important as the 911, the officer, or anyone. While I do appreciate, and I don't want it to go without being said, I appreciate what you're doing, and I do agree that the life of our first responders are in peril right now. I do agree with that. I don't like the fact that we're creating a difference for the life of one person over another, but I do appreciate the spirit of the bill. That's all.
Leader Lambert.
Thank you, Mr. Chairman. And to my friend's comments, I will say I signed on to the bill. I appreciate you bringing it. I don't think this committee or the sponsor or any of us would ever dare to differentiate between the value of one life or another. And this bill would only determine the sentence that someone would receive and recognize the aggravating factor that if you killed an officer in the line of duty, if you killed a firefighter in uniform while they're trying to save somebody else's life, it comes with an increased sentence. But I would never want this bill or any other bill to in any way determine the value of the life that has been lost. Because that family, whether it's a drunk driver that killed their loved one, whether it's someone with a gun or a knife or a club, regardless of what happened to lead to that point, that person's had everything that they were ever going to have taken from them. And so I think this bill really just recognizes the additional sentencing because of the fact that those folks, when killed, are doing so while serving us. And so I don't know if that helps at all with the point of this bill, but that's definitely why I signed on to it, is because when you've got an officer that's out there, when most of us hear gunshots or hear fire, I mean, we're headed away from that. We're going away from it. When our officers, our firefighters, our EMS folks, when something blows up, when something goes wrong, they're headed into danger. And the last thing they need to worry about is somebody lying in wait out there trying to kill them while they're trying to save our lives. So thank you for carrying the bill. Glad to support it. But I think extremely good comments by my friend. And I did just want to highlight that we would never, ever, in any way in the code, want to differentiate between the value of anyone's life, because every single time a life is taken, that's just it's an absolute tragedy and darkens this world. Thank you for bringing the bill.
Thank you. Any other questions for our sponsor, Representative Beck?
Thank you, Mr. Chairman. And I was just trying to get in my head exactly what is the law now, and how does your bill change the penalty?
I'm trying to follow Leader Lambert's orders here about recognizing the chairman before I speak. So
You recognized.
I have my counterpart here watching me, so I
Right,
want to
he's
make sure
taking
that,
notes too.
But yes, I can speak to that, Representative Beck. Currently, life imprisonment with the possibility of parole is an option for the jury. The defendant has to spend no less than 25 full calendar years of the sentence before they are eligible for parole. This bill would remove that option.
Representative Beck.
Thank you. Okay, I'm just reading here, and I apologize, I didn't read it beforehand. But it says, under present law, a person convicted of first-degree murder is punished by death, imprisonment for life without the possibility of parole, or imprisonment for life. This bill would require that the defendant be punished by death or imprisonment without the possibility of parole. So you're saying what I'm reading here is without the possibility of parole is not the case as we sit here, and this would make it the case under your bill, Leader Gant?
You recognize.
Yeah, like I said, the current life imprisonment with the possibility of parole is an option for the jury now.
Oh, I got you. Oh,
Yes, sir,
Mr.
go
Chairman.
ahead.
I've got you. Right now, you can either do imprisonment for life without parole, comma, or imprisonment for life. And under that imprisonment for life, you're saying that right now, you've got the possibility of parole, but under your bill, you're removing that imprisonment for life, and it would be with imprisonment for life without the possibility of parole. Is that, have I got it straight now?
Yes, sir.
Yes, sir, you do.
Representative Beck.
Thank you very much.
Any other questions for our sponsor? Question has been called. Without objection, we will be voting on House Bill 511 as amended. All those in favor say aye.
Aye.
Those opposed say no. The ayes have it. You move on to full criminal. For those that have wished to be recorded as a no, please see the clerk. Next item on our calendar, item number 3, House Bill 512 by Leader Gant. We have a motion and a second. Leader Gant, you are recognized.
Thank you, Mr. Chairman and committee. This is very similar to the previous bill. This allows a defendant to be sentenced to life without parole if found guilty of attempted first-degree murder of a first responder. First responders include law enforcement officers, correctional officers, Department of Correction employees, probation and parole officers, emergency medical workers, rescue workers, emergency medical technicians, paramedics, or firefighters who are engaged in the performance of official duties. This bill does not automatically give the defendant life without parole. This bill simply adds it to the list of possible sentences. That's it.
Thank you. Any questions for the sponsor? Representative Hardaway.
Thank you, Mr. Chairman. And to the sponsor, so I can appreciate this bill. And I wish the last one had that same option. But I'll be supporting this. Thank you.
Thank you. Any other comments or questions for the sponsor? We have one here, Representative Beck.
Thank you, Mr. Chairman. And Leader Gant, reading, again, I apologize for not reading this prior to today. Reading this only takes effect during participating in a riot, which creates a offense. Is that? Am I reading that correctly?
No, sir.
Okay.
It simply adds to the list of possible sentences life without parole.
That's because I'm reading the wrong one. I apologize. Thank you very much.
Any other questions for our sponsor? Question has been called. Without objection, we are now voting on House Bill 513. All those in favor say aye. Aye. Those opposed, no. Or excuse me, I'm sorry. Let's do a rewind on that. It's 512, House Bill 512. We are voting on House Bill 512. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Moves on to full criminal. Next item on the calendar, number 4, House Bill 513 by Leader Gant.
Thank you, Chairman and committee.
We need a motion and a second. All right, we have a motion and a second, and you are now recognized.
Thank you, Mr. Chairman and committee. Under Section 1, this bill, what it does, it increases the penalty of obstructing a highway or other passageway to a Class E felony and a mandatory fine of $3,000. Currently, which is a Class B or a Class C misdemeanor. Under Section 2, this bill creates criminal immunity from prosecution for any drivers who are exercising, and I reemphasize, due caution, who unintentionally cause injury or death to a person illegally obstructing a roadway. Under Section 3 of this bill, it creates a Class A misdemeanor for a person who throws an object at another. The key here is with the intent of harming the other person while participating in a riot. Section 3 creates a Class E felony for a person who throws an object at another person that actually causes bodily injury while participating in a riot. Section 4 creates a Class A misdemeanor for a person while participating in a riot who intentionally intimidates or harasses an individual in a public place who is not participating in the riot. And I emphasize, harass means to engage in conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose. Intimidate, under this legislation, means to frighten or threaten a person for the purpose of coercing the person to take some action. Mr. Chairman, I turn it back to you.
Thank you, Leader Gant. Are there any questions for our sponsor, Representative Griffey?
Thank you, Chairman, and thank you, Leader, for bringing this bill. I know there was a number of us upset with the events that we saw on TV regarding individuals who were illegally blocking traffic and banging on cars and destroying vehicles while people were in it and simply trying to get home to their loved ones or get to their job or something like that. My question is this: if a person is caught in one of these illegal protest or riots and obstructing traffic, and the individuals that are rioting, if they start destroying the vehicle and breaking glass and putting the individuals inside the vehicle in fear for their life, and the driver feels like their only option is simply to move the vehicle through this crowd in order to get away or else risk personal bodily injury, would you feel that that would be unintentionally causing injury or death if one of the rioters were injured while someone was trying to flee this life-threatening situation?
Well, Representative, obviously I can't make that determination here without having an exact situation, but our investigation of that accident would pursue that to make sure that that is fully investigated to determine that. But I want to go back to the language that's in the bill, that it says who is exercising due caution. And that would be up to the determination of that investigation to reveal whether that person used that due caution or not. And Mr. Chairman, I don't know if legal has a better explanation of that or not, or if they want to opine on that or not, but that's the way I interpret that, and I hope that's kind of answering what his question is.
Representative Griffey?
It does in part, but my concern is this: the language is somewhat non-specific, and I wish personally that language was a little bit stronger, that maybe add a provision if someone is simply trying to flee this situation to avoid the life-threatening situation and they happen to injure somebody in the course of fleeing, as long as they're not trying to intentionally injure somebody, that they would have immunity from criminal prosecution. I think that's, it's almost a flight self-defense. You're not trying to fight with somebody, but you're trying to get away and retreat and not become a victim. And I think those persons deserve protection from criminal prosecution. I think we've all seen problematic prosecutions regarding protesting and rioting in the past, and that's very troubling for me. I think everyone needs to insist that the rule of law is upheld. We protect the innocent and prosecute the guilty. So thank you, Mr. Chairman. Thank you, Leader, for bringing this bill.
Thank you, Leader Lamberth.
Thank you, and again, Leader Gant, thank you for bringing the bill as well, and obviously my co-sponsors support it. I mean, it does make it clear that you have this immunity if you unintentionally cause harm to someone else. I mean, if you're intentionally trying to cause harm, this bill won't cover you. I mean, that's not what we're trying to do here. I mean, it's if you unintentionally and you're exercising due care, if you're doing what a normal person would do in that circumstance, then this would cover you. But if you're intentionally trying to harm somebody else, it just simply wouldn't apply. Is that fair enough?
That is correct, and legal has combed through this, and this is the best language I think that we've put together. That, I mean, it just says who is exercising due care. So,
Thank you, Lee.
Any other questions? Representative Beck.
Thank you, Mr. Chairman. Leader Gant, thank you for bringing this after watching those horrifying riots in Washington this last month. I would hate for that to happen at our Capitol. So I appreciate you bringing this. So hopefully it will not. Thank you.
Any other questions? Seeing none, are we ready to vote on House Bill 513? We're voting on House Bill 513. All those in favor say aye. Aye. All opposed say no. The ayes have it. You move on to full criminal.
thank you, Chairman and Committee.
Next item on the calendar, number 5, House Bill 47. Representative Ogles, you have a motion and a second. You are recognized.
Thank you, Chairman, members of the committee. This bill is very similar to Representative Gant's bill earlier. So most of the questions you asked, the answer will be yes as well. This is a sentencing enhancement. It adds to the list of statutory aggravating circumstances for life without parole or capital punishment. And what this bill does, and as the committee spoke earlier, I have the highest regard for law enforcement, first responders, EMTs, paramedics, but there's also a group in Tennessee that we've kind of overlooked, and that's the Good Samaritans. So many times in the bill that passed last year, we had this all the way down to aggravated domestic assault. So many times in this state, people actually step in to defend other people. So this bill says if you're acting as a Good Samaritan and you're murdered, and a Good Samaritan means a person who helps, defends, protects, or renders emergency care to a person in need without compensation, that'll be added to the list of those 18 aggravated circumstances. And some of those circumstances we've added are for young people, elderly people, random people, drug dealers, things like that. Well, elected officials as well. So I would hate to not give people that are actually out there defending other people the same protection that is given to us. With that, I'll take any questions. Thank you, Chairman.
Thank you. Are there any questions for our sponsor? Seeing none. We will now be voting on House Bill 47 without any objection. All those in favor say aye. Aye. And those opposed, no. The ayes have it. You move on to full criminal.
Thank you, Chairman, members of the committee.
Next item on our calendar, number 6, House Bill 50 by Representative Ogles. You have a motion and a second. You are recognized.
Thank you, Chairman, members of the committee. And for those of you that were on this committee summer before last, you'll recall that this issue came up when Representative Lamar, we were working on her bill during summer study, and this is one of the best things I've seen come out of summer study. Actually, the only thing I've ever seen come out of summer study since I've been here. But what we found during that testimony is somewhat of an oversight that happened in the state years ago, and for whatever reason, rape was not listed as serious bodily harm. So therefore, if a person, if rape was committed against a person and they were to not properly articulate that they were in fear of their life being taken, the rape alone did not constitute serious bodily harm. So we're closing that loophole because now so many times, especially with video evidence being taken and statements being made, if for some reason a person were to only articulate they were either being raped or in fear of being raped, that would be enough to justify using deadly force. So what we've created is a subcategory for grave sexual abuse, which is rape, aggravated rape, rape of a child, and aggravated rape of a child. And everywhere that it says serious bodily harm, we've added the words grave sexual abuse. So with that, I'll take any questions.
Thank you, Representative. There is an amendment that goes on to this one here. We need to look at 003721. We have a motion and a second. You want to explain to us what that amendment does?
Thank you, Chairman, members of the committee. That was simply a oversight on my part. For whatever reason in the bill, it requires that the training of our police officers that be included, and I said the word police instead of peace officers, Peace Officers Standard and Training Commission. So post, I just put in the wrong word, so this fixed that. Legal called it, and we made that correction. We also changed the word back to 2020 Defense Doctrine because the House passed this last year. The Senate has yet to take it up. So we just kept that in there. Thank you.
All right, thank you. Question has been called on the amendment. So we're now voting to add amendment number 003721 to House Bill 50. All those in favor say aye. Aye. Those opposed, no. The ayes have it. It's now, we're back on the bill as amended. Any questions for our sponsor on this? Question has been called. Any objections? Seeing none, we're now voting on House Bill 50 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it. You move on to full criminal. Thank you.
Thank you, Chairman. Thank you, committee.
Next item on the calendar is House number 7, House Bill 0474 by Chairman White. We have a motion and a second. You are recognized.
Thank you, Chairman and committee. This bill that I'm bringing before you is one that was brought to my attention actually last summer. Started working on it. Let me tell you what the bill does, and then I'll give you more description as you prefer. It broadens the offense of indecent exposure to include victims who are 14 years of age or younger, or any age if the consent is not given, if there's an indecent exposure conducted in front of them, and it also increases the penalty for indecent exposure from a Class E to a Class C felony. The law is currently written. There was an actual case that happened in my community, and the way the law is written, it is only for 13 years of age and older and younger. And so an act was committed such as this, and the victims were 14. And it is my belief that at 13, 14, all of our young children should be protected. So this changes it to 14 years of age or younger, that if it's committed in front of them, then it's an offense, and at any age if the victim does not consent to any adult, which is 18 years or older. And with that, I renew my motion.
Any questions for the sponsor? Seeing none. Question has been called. Without objection, we're now voting on House Bill 474 by Chairman White. All those in favor say aye. Aye. All those no. The ayes have it. We move on to full criminal. Thank you.
Thank you, committee.
The next item on our calendar is House Bill 109 by Chairman Hulsey. It will be rolled 2 weeks per the sponsor's request. Jumping down to item number 10, House Bill 373 by Representative Cassida. We have a motion and a second. Representative, you are recognized.
Thank you, Mr. Chairman. What this legislation does, it signifies specifically that TWRA is not to put listening devices up on an individual's private property until or unless they get approval. As we all are in this room, we hold the ownership of private property one of the most sacred rights we have in the Constitution, and to invade someone's property without asking for their permission, I think, is an egregious act. And so this legislation says you just simply have to ask if you want to put a listening device on someone's private property.
Okay, very good. Do we have any questions, Representative Beck?
Thank you, Mr. Chairman. Representative Cassidy, you just said listening device, but what I'm reading says electronic surveillance. That would be a camera, would it not?
That's true. I was using slang, so thank you for pointing that out.
And what does TWRA post these electronic surveillances for?
You know, I wouldn't want to answer for them. Since I'm not involved directly with TWRA, I wouldn't want to answer for what reasons they have to justify their actions.
Have you had a complaint from a constituent in Williamson County of?
Not in Williamson County. There were, to my knowledge, based on an article that was written, there were 3 incidences that happened in Northwest Tennessee. It just it shook my righteous indignation that someone would put these devices without, it'd be like going to your house, Representative, putting a listening device on your property. They don't have a right to do that. They don't have a right unless they ask you to do it. I did give the bill to the senator that represents that part of the state, if it makes you feel better.
Okay, very good. Right. I thought okay, very good. Thank you.
Thank you. Representative Griffey?
Thank you, Mr. Chairman, and thank you, Representative, for bringing this legislation. I understand the concerns regarding law enforcement using electronic monitoring devices, trail cameras, listening devices, so forth. Are you aware whether the instances, I believe they happened in my district, and were actually...
One was.
One of them at least, or maybe there was 2, perhaps. Those trail cameras were actually installed at the direction of the U.S. Fish and Wildlife officials,
Which
or
again,
under their direction.
I am, but again, do we want the TWRA adhering to federal, or do we want them adhering to us? That's a question that's before us right now.
Well, but even if we pass this legislation, there would be nothing we could do to limit U.S. law enforcement, fish and wildlife officers from doing the conduct you're trying to prevent, though. Is that accurate? Do you think that's accurate?
That is accurate in that, but it wouldn't be Tennessee direct taxpaying dollars violating, to me, what's a basic constitutional right. Yes, the feds would come in and do it, but our people won't be.
Thank you, Mr. Chairman. I guess if we do this, do you not have some concerns that U.S. or Tennessee wildlife officials are not going to be able to monitor what happens with our wildlife populations, because our wildlife populations cross various private property rights and so forth, and if we set this up and we don't let our wildlife officials to go into farmland and open fields, are we not setting up a situation where somebody that wants to set up their own duck hunting, duck blind situation, and they've got 1,000 acres and they've got it posted all the way around, and then they just invite all their buddies over there, charge them a bunch of money, but they just hunt the you-know-what out of ducks and violate the heck out of our fish and wildlife laws, and there'd be nothing we could really do to catch them.
But 2 things to that, Mr. Chairman, I would submit is that, number one, there's many tools to capture illegal activities. This is just one of many. But number 2, one of our basic rights, again, is that we are innocent until proven guilty. If there's probable cause, that precipitates a whole different set of actions that they are to take.
Is there a reason why you focus on just on TWRA and not all law enforcement officials in the state?
There's really not, and I considered making this bill broader, and I know for a fact there's another representative that's got a bill that is much broader, and he and I talked, and if this committee wants something broader and stronger, then you guys tell me right now, and I'll take this off notice and let him run his bill. But I'm a little hesitant on law enforcement. I personally wanted to do only TWRA.
Thank you, Mr. Chairman. We passed the what's the Drone Act Let's see, where did I put that? Tennessee passed the Freedom from Unwarranted Surveillance Act regarding the use of drones to gather evidence or information. It's got some pretty stringent standards in there, and they've got to be reasonable suspicion or a warrant requirement or consent. You can only collect evidence for no more than 3 days, and you got to either, if there's evidence of crime, you got to go back to the judge and get a warrant or destroy it. Even if you observe some criminal activity that's not related to what you originally requested the surveillance drone for, you can't even use it to go against and prosecute that criminal offense. I kind of wonder, for purposes of consistency, whether we might be smart to take a look at that and see if we want to limit what law enforcement does with technology. And that's a huge problem that we're all facing. And if I recall correctly, I think the Supreme Court came up with the open fields doctrine because they said the Constitution says it protects the person, not places. And therefore, they said it applies to your person, your home, your effects in the home, and that it didn't apply generally outside the curtilage of your home. And that way, if somebody's doing a meth cook or something in the middle of a field, they don't really have an expectation of privacy there because helicopters could fly over and observe you. So I just kind of wonder whether if we're not careful, we may throw the baby out with the bathwater on this. I get where you're coming from, but I would just urge this committee to use caution, and maybe we ought to look at this issue a little further before we vote on it.
And Mr. Chairman, if I could add to that, that's one of many tools that you just mentioned why they can catch poaching. This simply deals with attaching those devices on property, but there are many other tools to catch illegal activities, and so this won't limit poaching at all. So help me get this out of committee, and I'll work with you on it.
Thank you. Do you have anything else? All right, Vice Chair Sexton, you're recognized.
Thank you, Chairman. Would this bill cause law enforcement to not be able to ask the homeowner or the landowner if they could come on their land?
It would not, and actually, it's the very reason why I'm carrying this bill, Representative Chairman, because I do want TWRA to ask the property owner, can I do this?
If the homeowner or the landowner decided not to, does it impede the TWRA from maybe seeking a warrant?
No, not at all.
They could still seek a warrant, or I have to commend you for this bill because property rights are very important as part of our foundation and Constitution, and I think we need to reserve and preserve that right to property owners and not give big government the freedom and these departments to do as they wish. So I commend you for this.
Thank you. Thank you, sir.
Thank you, Chairman Howe.
Thank you, Mr. Chairman, and thank you, Representative Casta, for bringing this bill. You mentioned your indignation when you read the story. I share that with you. And I think one of the stories I read said that when the agents, TWR agents, came to collect their video equipment and audio equipment, it wasn't there because the homeowner had taken it down, or the property owner had taken it down. They went to retrieve it from him and threatened him with legal action because he had taken it down. It was on his own property. And he said, well, he didn't have permission. Well, they said, we don't have to get permission. My question is, why should TWRA be exempt from all the other law enforcement agencies in the state of Tennessee who have to get a warrant, or the judge has to sign a warrant and violate property rights of an individual? I personally have some wildlife on property where I live. I've seen deer and muskrats and geese and ducks and red-breasted hawks and even squirrels now and then. And if TWRA came to me and said, we'd like to put up some surveillance cameras to see what that red-chested hawk is doing, I would say yes, because I'd like to know. But I want to know about it. And so I appreciate your bill, and thank you for bringing it.
Thank you, sir.
Thank you, Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this bill. We talked before,
Yes.
and the only reason I asked to be recognized is because you had mentioned earlier that there is another bill that's broader.
Yes.
Just if it comes to a vote, I just want you to know that I feel like we shouldn't single out TWRA. If this is sauce for the goose, it should be sauce for the gander. Sorry, pardon the expression when TWRA is involved, but
It's goose hunting season.
that's right. But so that's my only concern. I hear what you're saying about private property rights and righteous indignation. I just, if we're gonna do this for one, then let's make sure that everybody's playing by the same rules.
Mr. Chairman, if I could add, the chairman and I had this conversation this morning at his desk, and he told me what he had, and I said, well, what I would like to do, and if the committee approves, I would like to get this through subcommittee, and I committed to the chairman, Faison, that I would park it, and if his got out of here, then I'll let him take the lead. And so that's a deal I have with Chairman Faison, and if that's palatable to the committee, that's a deal I'll make with you guys, that get it through sub, so I don't have to come back at 5 o'clock in the evening. Never mind. And and I'll park it, and then we'll see if you guys like Faison's bill better.
Any other comments or questions for the sponsor? Representative Hardaway.
Thank you, Mr. Chairman. Good afternoon to you, the sponsor, or good evening.
Good evening.
Under current law, is there anything that governs the storage or the use of that data that's collected?
To my knowledge, the law doesn't address it. It's not addressed.
All right. And right now, there's nothing that requires the agency to get permission from the homeowner. Is there anything that requires them to give notice to the homeowner that it's been done?
According to my research, and I've been wrong once in my life, there's not. It just doesn't address it, Representative. It just doesn't address it.
Okay, it's just quiet on it, period. All right, thank you. I'm agreeing with my colleagues who cited property rights, and I'll be supporting it.
Thank you.
Thank you. Are there any other, Representative Griffey?
Thank you, Mr. Chairman. And I appreciate you bringing us. I just have one last sort of question. Human nature being what it is, we're not all angels. There's some real bad actors out there and people that do what they can to abuse the system and get away with stuff. So what do we do about the individual who wants to set up an illegal duck hunt, dove hunt, shooting, all the trophy bucks out there and everything? And because of the nature of wildlife that is owned by every citizen in the state of Tennessee, nobody has a right to claim more than what we all set up here as what should be the legal limits or the authority we give TWRA to set those limits and stuff. How do we protect the interest of the citizens that have an interest in that and keep the bad actors from abusing the system if we enact this bill?
I think you've identified for the committee yourself. One of those is drones. One of those is warrants. One of those is old-fashioned observation. And so there are dozens of methods that law enforcement investigates suspect crime without abridging our constitutional rights.
So your bill is not to ban law enforcement or TWRA officers, wildlife enforcement officers, from entering private property. They just can't enter private property to install a trail camera without a warrant.
Or more importantly, as the bill specifies, permission.
So you got to have warrant or permission. Otherwise, they can walk across someone's posted property, right, and if they catch observe somebody violating the wildlife laws, this bill's not going to prevent them from charging them and pursuing them.
That's right. And if I hate to be redundant, but this bill does one thing. It just says you can't put those devices on the property. That's all that bill addresses.
Thank you, Mr. Chairman. Thank you, sponsor.
Any other questions, Representative Hardaway?
Yeah, that last statement, Mr. Chairman, you said it's only about putting the devices that doesn't speak to drones.
Does not.
Okay, thank you. Thank you, Mr. Chairman.
Any other questions? Any objection to the question, calling the question on the bill? Seeing none, we're now voting on House Bill 373. All those in favor say aye. Aye. Those opposed, no. The noes prevail. The bill fails.
Mr. Chairman, what's the count on that?
It was a voice vote.
Okay.
Or
What was the numerical on that?
that's, I'm going by my ears there, sir, is what I heard. The noes prevail.
All right. I guess I would be asking too much if you did a roll call vote? I understand.
That is something that has to be requested before.
That's why it was just a request and not I have no standing under the Tennessee House rules. I understand. It was just a polite request.
All right. Well, thank you.
Okay.
Next item on the calendar is House Bill 374 by Representative Cassida. Motion. We have a motion and second. You are recognized.
Simply put, those that serve on community oversight boards will attend the Citizens Academy of their police departments. The idea here is just to further grasp the depth of the activities of our police officers, especially if you're serving on an oversight board. Helps you understand their day-to-day activities.
Thank you. There is an amendment on this, 003711 by Representative Griffey.
Thank you, Mr. Chairman. I'm requesting a motion and a second on the amendment.
Is there a motion and a second on this amendment? There's a motion and second. Okay, you're recognized.
Thank you very much, Mr. Chairman, and Representative for bringing this bill. My concern is, and everyone should have a copy of the amendment if they don't have it. What it does is it requires, if you're going to have a community oversight board, it must be composed of only 9 members, and you have to have individuals with these minimum qualifications. 1 member with at least 5 years' experience in state as an elected judge with criminal jurisdiction. 1 member with 5 years' experience in the state as a district attorney general, assistant district attorney general. 1 member who's an attorney licensed to practice law in the state with 5 years' experience in criminal law. 1 member with 5 years' experience in federal, state law enforcement officer or investigator, including but not limited to employee of the Tennessee Bureau of Investigation. 1 member with at least 5 years' experience as a local, state, or federal education official, including but not limited to an elected school board official. 1 member with 5 years' experience in the state as elected local, state, or federal official, including but not limited to state or federal representative or senator. 1 member appointed by a local legislative body of the jurisdiction for which the Community Oversight Board is established without any other qualifications. 1 non-voting member appointed by the mayor of said jurisdiction without any other qualifications, and 1 non-voting member of legislative body of jurisdiction which the Community Oversight Board is established. Mr. Chairman, the purpose of this is I'm concerned that some of these community oversight boards are being unfairly used and driven with a political agenda rather than getting at facts and circumstances involving the unfortunate loss of life, involving shootings, involving law enforcement. And so the intent of this amendment is to set out some broad specifications such that we have people who are qualified with some experience in the background. Officers involved shootings are investigated by our district attorney's offices, which the district attorney is elected official who has ultimate charge and responsibility. I get it that some people are concerned that law enforcement sometimes gets an unfair pass or not looked as critically by others, and the community would like some sort of oversight into that review process, and therefore they have these community oversight boards. So I get that, and I want to support that, but at the same time, I don't want this process to be manipulated and become a political tool or political agenda and used for unfair purposes, because the people that are involved on both sides of an unfortunate officer-involved shooting deserve fairness and justice and not be subject to political winds. So that's the purpose of the amendment, and I would urge the committee to adopt it. So thank you, Mr. Chairman. Thank you, sponsor, for bringing this bill.
Thank you, Representative Griffey. Chairman Curcio, you're recognized on the amendment.
Thank you, Mr. Chairman. And to the sponsor of the amendment, I apologize we didn't get a chance to speak about this earlier because what I'd like to share, first of all, I agree with everything that you just said as far as these oversight boards not being used for political purposes and so on and so forth. And the only reason I speak up now is because I've got a lot of subject matter history on this because I was the member who brought the legislate or the code section that we're now actually amending. And in those days, I worked with a Speaker of the House and a very active and engaged committee, Judiciary Committee. And in fact, most of the hearings were held in this room, and they were very contentious, many hours of discussion. But we wanted to be very clear to try to thread a line. So just to kind of bring everybody up to speed, because many of you weren't involved in this conversation, was to try to thread a needle between making sure we adhere to best practices as outlined by the National Institute of Justice, which we spent many, many days poring over to make sure that we were setting up this board in Tennessee. If we're going to have these boards, we want them to be adhering to the best practices to national standards. And so we looked at, in-depth studies that looked at what these oversight boards did and how they functioned in other states and across the country. We also wanted to try to leave as much to local control as possible. So the approach that we took at the time, and it doesn't mean that this committee tonight would necessarily agree with that. I guess we'll find out here in a moment. But the approach we took at the time was to try to set up some guardrails, if you will, some parameters, and then allow locals to work within those parameters. So the NIJ study that we used and worked with outlined in essence the parameters that we have today. And so I think, with the exception of what the member is trying to do today, which I think is a good edit, I am hesitant to go back to the drawing board completely and restructure the boards. This here, we're really dictating to locals what they've got to do, kind of, chapter and verse, comma and period. Whereas, the approach again that we decided to take 2 years ago was, all right, what are the best practices? Where is it working well? Because I like it when Tennessee leads and when Tennessee says, look, you may not agree that these boards, you may not like these boards, for example, and I know we all probably have our own personal opinions about them and about whether or not they could be used for political purposes or not. But the fact is, if the boards are here, we want to make sure that we've got the best ones anywhere in the nation, and that's why we wanted to adhere to those best practices. So I just want to kind of add that sort of institutional knowledge and take that for what it's worth, and I'll kind of lay that at the feet of the committee. And again, I'm sorry we didn't have a chance to have this conversation earlier because I honestly wasn't aware of the amendment until just before committee. So thank you for your indulgence. Thank you, Mr. Chairman.
Any other questions, comments on the amendment? Seeing none, any objection to calling the question on the amendment? Seeing none, all those in favor of adding amendment number 003711 to House Bill 374, say aye. Aye. Those opposed? No. The noes prevail. The amendment does not go on the bill. We're back on House Bill 374. Representative Castor, you are recognized.
No further comments.
Leader Lambert.
Thank you, and thank you for just bringing the bill. I mean, I think it is a significant improvement to what was there last year. I mean, these, community oversight boards serve a very valuable function in the community. But, I mean, in order to be able to do that well, they really do need to have this knowledge. So, I mean, I think you're doing them quite a favor here by passing this into state law, and I commend you for bringing it. Thank you for bringing this piece of legislation. And I thought I had signed on already, but would love to do so for whatever that is worth. So thank you for bringing the piece of legislation. I certainly plan to support it. It's a very good bill. Thank you.
Love to have you.
Representative Griffey.
Thank you, Mr. Chairman. I echo the leader's comments. I fully support your legislation. I love the amendment, but I think it would be smart if we at least set a little firmer guide rails, as the Chairman Curcio mentioned. So, but thank you for bringing this. I'll definitely support it.
Representative Russell.
Thank you, Mr. Chairman, and thank you, sponsor, for this legislation. What does the police oversight committees currently have to have in training?
To my knowledge, let me defer to the mother of the. Can I refer to Chairman Curcio on that? Mr. Chairman, can I defer that to Chairman Curcio?
You may, Chairman Curcio, if you want to answer this, you may.
Thank you, Mr. Chairman. Again, trying to adhere to those best practices nationally, there's not a specific training requirement. We tried to leave that up to local jurisdictions, again, respecting local control, but there are restrictions on who can serve on the board. So And I don't have those in front of me. I certainly 2 years ago had them all memorized and answered many, many press inquiries and cross-examinations about them, but I don't have them memorized today. But there's not a specific training they have to go through as much as that we talk about if there are certain folks who are prohibited from serving on the board, and within that, we allow locals to control their board the way they'd like. And I will say, since the question came from a representative from Shelby County, that at the time, the city of Memphis felt like this legislation in no way impacted with the CLRB, and felt like they had a good thing going, and this bill did not interfere with them one iota.
Thank you, Mr. Chairman. If I understand this right, it requires that members of a community oversight board complete the local police force assistance academy course within 6 months. What if they don't have an academy within the 6 months?
Then they're exempt.
Does it say that in this?
It does.
statute? Okay, thank you. It's a good bill.
Thank you.
Representative Beck.
Thank you, Mr. Chairman. Representative Cassada, am I reading this correctly that if one of the members has not completed police academy within 6 months of being appointed to the committee, then the entire agency loses its authority under this section?
I think that's a good motivator to attend the class.
Representative Cassada, they don't all, I mean, these are staggered. I understand your thought in wanting them to be well-rounded, and I think that's a good thought, but this is draconian to say that if one member, for some reason, illness or the class doesn't make, is going to shut down the whole community oversight board. It's a poison pill to the whole community oversight process, and I can't support it. And Memphis and Knoxville did great for years, and ours has just started, and the guardrail set up by Chairman Curcio. Everything's going well. I understand your sentiment again, but can't vote for something that is going to just totally take away their authority for something that may not be under their control. I mean, the class may not make, there may not be enough people, there could be illness, and yet you're going to shut down the entire process in Nashville, Memphis, and Knoxville for what could be excusable to neglect, but there's no wiggle room here. There's,
Right.
The chopping block comes out, okay?
And to that, this is an idea that I bring to the committee. The function of the legislative process is, with several of us, we make something better. So if someone has an idea, approach me before committee, and I'll work with you on it.
Representative Russell, you're recognized.
Thank you, Chairman. And just to clarify, what happens if that authority is taken away? What does it revert back to?
Obviously, the committee the oversight would still exist, but the authority that was given to them by local government would no longer exist.
And if I understand correctly, their internal affairs would take care of the problems that may arise?
That would be my understanding.
Thank you.
Representative Griffey, recognized.
Thank you, Chairman. Representative, it seems like that it would only be a temporary suspension of the oversight authorities to take any votes or any action or do anything. They could still meet, I guess,
Yes.
review cases. They just couldn't formally vote, have any voting power until that one person or two people complete the course. And then I guess as soon as they complete the course, they just come back and, hey, we're going to vote on this thing we've already been reviewing. Is that a correct understanding or
Yes,
not?
sir. That is the legislative intent of this. That scenario you just outlined.
Any other questions for our sponsor? Okay, if you will, I heard someone call the question. If you will, I've got two things. If you wouldn't mind withdrawing that. We'll go out of session and recognize legal for a moment. They've got something they want to add, and we'll come back in and recognize Representative Hardaway. We're going out of session.
I just wanted to add that under 38.8.312, the Community Oversight Board does have authority to request subpoenas through a local legislative body, so that power would also be something they would lose, assuming they didn't comply with the training.
Okay, thank you. We're going back in session. And Representative Hardaway, you are recognized.
Thank you, Mr. Chairman. And I just want clarity from the sponsor on how to handle the individual who may not get the training. If that individual does not attend a meeting, will that meeting and its actions be legitimate?
That I asked it, and I appreciate legal, they did a good job. We had several back and forth. The intent that I have, and the bill reads it well, is that they just lose their authority. The oversight board is not dissolved. They just lose their authority that's been granted to them by that local government until that individual attends the police academy, Citizens Police Academy.
All right, maybe I wasn't clear. If the individual does not attend an oversight meeting, then there's no violation under this proposed legislation.
This bill doesn't address that at all. That's correct.
All right, and the definition of the actual citizen training program, the education program, is there anything in current statute that defines it, that sets out the programming, the structure of it? Is there a cost? Anything in statute currently? And
Chairman,
if so, does this impact that at all?
Right. Mr. Chairman, can I defer that question to legal because I'm not aware of what is in code regarding citizens academies?
You may, and we'll go out of service without, or out of session without objection.
The bill defines a citizen police academy as any program established by a law enforcement agency to educate citizens on law enforcement operations, practice, and training.
Right, so that would be, those parameters, criteria would be set by the local folk?
Yes, sir.
All right, thank you, Mr. Chairman.
Okay, we're going to go back in session. I didn't know if your question was for legal there, but we'll go back in session. Do you have anything else, Representative Hardaway?
Actually, it was, sir, but I appreciate the sponsor jumping right in there.
Okay, well, all right. Representative Howe.
Thank you, Mr. Chairman. To the sponsor, do you have any idea how many citizens academies there are in the state?
Mr. Chairman? I don't. I know the large metropolitan areas have it. I know my towns and my do. So most decent-sized towns in the state of Tennessee does.
Thank you for that. I believe Bradley County has one sponsored by the Sheriff's Department in cooperation with the Cleveland State Community College. I have known people who have attended that academy, and they usually have quite a large class. But people have said to me how it changed their view of what our law enforcement officers face on a day-to-day basis. And if I may, Mr. Chairman, I have a grandson who just was hired by a good-sized police department in the Midwest. He follows his father, who just retired after 22 years as with the Sheriff's Department. And I know a little bit about how these people are hired and what they go through when they are hired. You don't just put in an application. You go through several steps, including a psychological evaluation, your ability to act under pressure. It's really, really intense. And quite frankly, I'm not sure I could pass it. But in my grandson's case, he had just gotten out of the military. He'd spent 3 years in the Army and quite some time in the Middle East and saw action in the Middle East. But yet when he came home and got hired with the police department, he had to jump through 5 different interviews, including 2 psych evaluations. And now he's in the police academy until October 1st. These guys are really trained, folks. And for me, I think this is a great bill because for a citizens police academy, for a citizens oversight community board with no indication or no appreciation for what these officers go through and how well they're trained, it's offensive to me that they would sit in judgment of our law enforcement agencies who are, for the most part, are doing their level best to protect us. Thank you, Mr. Chairman.
Thank you. Any other questions? First question has been called. Without objection, we are now ready to vote on House Bill 374. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Thank you. No, sir. All right, members, we are going to jump around here for just a moment. We're going to pick up item number 13 on your calendar, House Bill 217 by Chairman Curcio. A motion and a second. You are recognized.
Thank you, Mr. Chairman. Thank you, committee. Members, this bill was actually brought to me by the Sheriff's Association, and they had identified a problem that we were having in parts of the state when if a bail agent were to partner up with another bail agent who was not on the same bond. So I'm a bail agent, I'm on a bond, and someone skips on me. At that point, I really need to go hire a bounty hunter if I don't think I can get them on my own. Well, what was happening in some pockets of the state was that bail agent was instead going to one of his associates, one of his buddies, and partnering up with them and said, come on, let's go get them ourselves. Well, at that point, they're really behaving as a traditional bounty hunter. And in this state, we have a different set of training standards for bounty hunters that they have to adhere to. Since these guys were bail agents, they were not trained in that way. We're not adhering to the bounty hunter standards. So what this bill does is it simply puts them on a level playing field so that if they're acting as a bounty hunter, they have to have the training as a bounty hunter, have the certification as a bounty hunter, and behave as a bounty hunter. Nothing in this bill would prohibit a bail agent who's on a bond who skips, who's just working on their own, from doing everything they could within the law to go get that person themselves. It's just if they partner up with another bail agent for the purposes of acting like a bounty hunter that they would have to behave like a bounty hunter and follow all the other regulations as a bounty hunter. That's the meat of the bill. That's most of what you see there. At the very beginning of the bill, what we've also identified is several years ago, a former chairman of this subcommittee actually created something called the EMIF, the Electronic Monitoring Indigency Fund. And if you'll go there with me for a second, what this fund does is if Representative Beck and I are both before the judge and we're both a good candidate for monitoring, and he, of course, is very well-heeled and can afford the monitor, but I myself am indigent and cannot afford the monitor, we have equal protection under the law, okay? So I don't have to go to jail just because I'm indigent, and you get to go free and go home on a monitor because you can pay. We set up the Electronic Monitoring Indigency Fund to pay for folks who are indigent on these monitors. The issue is we have an undefined amount of claims for an undefined amount of money. So every year that EMIF, at least the last several years, has been running out of money, and we as a state with a $2 billion surplus are asking the criminal monitoring industry to tote the note for the state of Tennessee. So they're actually having to work for free, and if they go to the judge and ask if they can turn the monitor off, unfortunately the answer that they're getting, if they're even brave enough to ask the question, the answer that they're getting is no. If you turn that monitor off, you're in violation of judge's orders, and guess where you get to go? So what this bill simply says, at least the first section of the bill that I'm talking about, is if the state EMIF fund or a local political subdivision, for example, Metro Nashville has their own similar indigency fund, if they run out of money, which they often do, there's a 30-day notification period where the state will notify the judge and the appropriate government involved and say, hey, red flag here, we're running out of money. 10 days out, they say, hey, now we're really running out of money. That gives that judge the opportunity to know, okay, this defendant is about to violate a condition of their bail, or of their bond, because remember, these are pretrial folks. So they're about to violate a condition, which is that they would be out on a monitor. So that gives the judge the opportunity to direct the sheriff to go and get the person who is now in violation of that condition, of that bond condition. So a little bit of nuance there. I'm happy to answer any questions that anybody has, but that is what the bill does. And again, the meat of this brought to me by the Sheriff's Association, and something that we've been working very hard with both the Bail Association and the sheriffs on.
Thank you, Chairman Curcio. Chairman Farmer.
And thank you, Mr. Chairman. And to Chairman Curcio, I had a couple questions. Had some folks come up to me and are concerned about, is this going to put our bonding agents in any sort of adverse situation? Is it going to cause them any extra workload on them?
Thank you, Mr. Chairman. And thank you, Mr. Chairman, for the question. It shouldn't have no impact on the bonding industry at all, and maybe I probably didn't explain it well enough, but if this were to occur, it would be before the appear date. So when a bail agent is on a bond, that's an appearance obligation, right? So basically that bail agent is saying, Judge, I promise you this guy or gal is going to show up, and if they don't, I'm going to go get them, and if I can't find them, then I'm on the hook. That has not, under this scenario, we haven't reached that hearing date yet, that appearance date yet. This is happening before the appearance date. So if the state or the local municipality that has an indigency fund stops paying for that monitor, that's totally, that has nothing to do with failure to appear. That's just, this person has now violated a condition of their bond in that they are no longer being monitored. So this actually doesn't involve the bail agent at all, because we've not reached that appearance date yet. This sort of happens before the bail agent gets involved at that point.
Okay. Mr. Chairman, may I? And just to follow up on that, so hypothetically, if we're in a situation and I have a client that's out on bond and he's been monitored, right? So the probation officer, whomever is monitoring him, calls the sheriff or whomever and says, look, we're out of money. They gets notice, we're out of money. We're not going to be able to be funded for this GPS monitor anymore. So what's the next steps? Does the sheriffs then go out and pick this individual up? Does this individual get a phone call and say, hey, come back here, we need to figure out some way to monitor you? Because I'm sure he's having to report pretrial anyway. So just kind of curious how that works. You know, I just want to be sure that we're not causing any more work or putting our bonding companies in a position to where they could have their bonds, the judge say, you know what, we're going to issue a forfeiture on your bond and you're going to have to pay this now because this defendant isn't here. So I think that's the concern.
Thank you, Chairman Farmer. Great question, and no, because again, when the notice goes out from the state to the judge and to the local government, they say, we're running out of money. Once that fund runs out of money and then they're going to turn that monitor off, once that monitor is turned off, again, the defendant's not notified of that, okay? The judge and the local government are notified. That's who gets that notification that's going to be turned off. At that point, that person has violated the condition of their bond because they're no longer on a monitor. A condition of their bond was that we'll let you go because you're able to pay for an electronic monitor. The way they're able to pay for it is the state of Tennessee or Metro Nashville, whomever, is paying that $8 a day, whatever that fee is. So at that point, the judge then, just like if they had violated in any other way, notifies the sheriff, and the sheriff goes and picks them up. The bail agent is not involved because we're not at the appearance date yet.
Any other questions for the sponsor? Representative Griffey?
Thank you, Chairman. I had a question for legal. It's probably best for legal. What instances is transdermal monitoring required under Tennessee law? Like the second, third DUI, fourth DUIs, any other offenses that are required to have transdermal monitoring? Thank you, Mr. Chairman.
Thank you. We'll go out of session and hear from legal.
I believe, I'm going to have to find the citation, but I know there are some specific alcohol-related offenses where it is required. But I think the court could order it if they find it's a reasonable condition of bond and is necessary to ensure appearance. They could order it for any offense.
Okay, we'll go back in session unless you have any other questions for legal, Representative Griffey. All right, we're back in session. Representative.
Thank you, Mr. Chairman. My concern is this, that if we've got some statutory provisions that require transdermal monitoring, it seems like that according to this language, if they're running out of money, the monitoring company, bail bondsman, will notify the court. But there's no requirement that the defendant come back into court unless the judge issues another order to locate the defendant that gets to him at his address where he's supposed to be to come into court and see what other arrangements may have to be made. I'm concerned that I saw recently in the news that Rutherford County's got a system where they're just releasing everybody ROR with no bonds posted or whatever. That might be appropriate for some defendants, but my experience has been it's generally not an appropriate response, a broad brush response to everybody that comes through General Sessions Court or Circuit Court, at least where I'm from. And my concern is that if we don't have some provision that requires a defendant to appear in court, if the money's out and there was a statutory requirement for monitoring, that we're going to create more problems for ourselves. I did have one other question and concern, was on the Section 5 that requires or prohibits bail bonds from making representations that they're a member of a law enforcement organization or wearing law enforcement insignia or uniforms and so forth. Is that a problem that currently exists in Tennessee that we need to address? And I'm kind of wondering whether, if you allow bail bondsmen, bounty hunters to wear insignia law enforcement, I kind of wonder if we might get a better benefit, because I think defendants who are already failed to show up for court, if they think they're dealing with a law enforcement officer, they might be less likely to flee or engage in violent behavior with the law enforcement officer. If they think it's just a bail bondsman, they might take their risk and try to get in a scuffle and get away and flee. I just kind of whether we might have unintended consequences for that. So thank you, Mr. Chairman. Thank you, sponsor.
Thank you, Chairman Curcio.
Thank you, Mr. Chairman, and thank you, Representative Griffey. I know we had talked about this earlier, and I'm glad we're getting this on the record. This Section 5 simply just mirrors what the bounty hunters have to do currently. So the bail agent can't impersonate an officer. The bounty hunter cannot impersonate an officer. What this bill is regulating is when a bail agent teams up with another bail agent to act like a bounty hunter. So what we're doing is we're leveling that playing field so that no one can impersonate an officer. So right now, a bounty hunter can't do that, and a bail agent can't do that. And so this is sort of a new third leg of the stool, if you will, is when bail agents are teaming up and acting like bounty hunters, they have to follow the same rules and regulations as bounty hunters do. So this is not a change to current code; it's actually a mirror of current code.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman. To the sponsor, I want to understand a couple of things. One is on the bounty hunters, those who are assuming the status of a bounty hunter when the bail agent and his friend decide to engage in that practice. Will the friend and the bail agent be in violation? Will the bail agent incur penalties along with the friend, or just the friend? And I would say conspiracy, but I don't know much about the law, so.
Thank you, Mr. Chairman. Again, I don't want to muddy this water too much. if a bail agent is acting on his or her own and they're going after somebody who skipped on them, they have the ability within the confines of the law to go after that person, and that's part of their business model. If they cannot perform that duty, or if there's some reason why they need help, they typically would hire a bounty hunter. In very rare instances, but it is happening, and with detrimental outcome, in very rare instances, a bail agent is calling up one of his friends who is also a bail agent and saying, let's forego paying the bounty hunter and just go get them ourselves. It's sort of a Wild West posse situation. What we're trying to say is that when you do that, you can't be a Wild West posse. You've got to behave, walk and talk, and be regulated like a bounty hunter. So this simply says that they must have those same credentials, follow the same rules. So to answer your question directly, it doesn't matter whether I'm the agent that was on the bond or whether I'm the associate. If we're acting as a bounty hunter, we've got to walk and talk and perform like bounty hunters.
Okay. So the bail agent, if he's part of the friend and the friends of fronting to be the bounty hunter, then the bail agent is just as guilty.
Yes, sir. Anyone who's under this law, anyone who's behaving as a bounty hunter must behave as a bounty hunter.
All right, very good.
Thank
Now,
you, sir.
the part I'm having a problem with is when we're yanking an individual back into custody, and I think it may have been Rep. Griffey that spoke to this, without them having their day in court. And I'm not clear on whether you said they will have their day in court or the sheriff will pick them up, they go straight to jail, and they have no way to appeal to the court before they're yanked off their job or out their house in front of their children in the morning or whatever.
Thank you, Mr. Chairman. No, that would be a separate violation, a violation of their condition of release. And so they would be able to go before a judge to try to work out a new agreement. At that point, they may say, look, since I've been out on monitoring, I've been able to work, and now I can afford the $8 a day for the monitor, and they turn around and go right back home. But they would have their day in court, to use your terminology.
All right, so they would be picked up and taken to court or picked up and taken to jail to await an opportunity to appear before the judge.
They would be given notice and a hearing would be scheduled.
All right, thank you. I've got a problem with that.
Thank you, Representative Moody. You recognized.
Thank you, Mr. Chairman. I would be remiss if I didn't let the members here on the committee know I have a constituent here, and he's Ernie Arredondo, and he is from Tipton County, and he is a bail bondsman. And I'm trying to acclimate myself to criminal and have no ability to really argue or just to let you know that he did come up here. He did meet with Chairman Curcio, and thank you for that for doing that. And all I can tell you is I know, as I listen to my constituent, he has some concerns also. And so I just wanted to make that clear to everybody and to let you know who's here in the room that's from my district.
Mr. Chairman. Thank you, Representative Farmer, Chairman Farmer.
Yeah, and thank you, Mr. Chairman, and to Chairman Curcio. I had, as you had said earlier, talking about equal protection, right? Someone who can afford to pay for this device versus someone who can't, right?
What?
Okay, so you have an individual who can afford this, individual who can't. So then the state steps in and says, you know what, we're going to pay for your device in hopes of avoiding an equal protection claim. Now, if once the state runs out of money and they can't afford to pay for this device, are we not back in that same circumstance there with an equal protection claim?
Again, at that point, if they violated a condition of their release, they'll go back and before the judge and have to strike a new deal.
In this situation, it wouldn't be them that would be acting in a manner that would be willful. It would be the state's inability to pay the monitoring company, right? So in that scenario, would a court or could a court issue a violation of that probation? I just see the state, coming up short in providing them with that constitutional protection. Just out there, I'm just kind of thinking, I just want to keep us out of a bad situation potentially. So as long as I just wanted to put that out there.
Sure.
Thank you.
Representative Beck.
Thank you, Mr. Chairman. And 1 minute, I think I've got this, Chairman Curcio, and the next minute, I think I don't.
You can just vote yes.
Let me go back to your example at first, where I can pay for my monitoring unit and you can't. So in order for us not to get into a equal protection, we've got the state coming across with this indigent fund, which is a wonderful, wonderful thing. Now, 2 months into it, all of a sudden the coffers are going dry on the indigent fund for the monitor, but yet I'm still out and about paying my own, and then the person who gets violated, and that may not be the correct term, but they can't, their monitor's not going to be paid for anymore. So in my mind, that would be a violation, and they're pulled back in and they're told, if you can't pay for the monitor like Defendant Beck is doing, then you're going to go into the clink. How would that not be an equal? Going back to Chairman Farmer's question, how would that not be an equal protection problem?
Thank you, Mr. Chairman. Because again, I think we're making a lot of assumptions here.
Okay.
You go back before the judge may say, you know what, we got a very able bail agent here. He'd love to take you on as a client. Have a nice night. So we're assuming that the monitor is going to be required again. We're also assuming that the person has not gotten a job and can't afford $8 a day, right? But the brass tacks fact of the matter is the monitor is no longer being paid for, which is a violation. So what happens when they come back in before the judge is a whole new discussion.
So what you're saying...
Sorry. For example, the judge may say, I have it on good authority that the state no longer funds this program. So I'm not going to require a monitor. I'm going to require a bond.
So I guess, and I don't mean to put words in your mouth, are you saying that it was a luxury that the state had that money in that indigent fund, and as soon as it ran out, he's back in the position that he would have been without that indigent fund to begin with? Is that what?
There is some reason why that defendant was not released on their own recognizance. So they decided to either put him on a bond or put him on a monitor or both. At that point, you could either make your bond, agree to pay for the monitor, or say, no, I'd rather sit in jail, right? That's how that works. And in this instance, the person said, I can have a monitor. Judge says you're a good candidate. And they fill out a form that says, well, but I'm indigent, so the state pays. Yes, that is a very fortunate position to be in. But if you violate that, then we have to come back in and have another conversation.
But the violation is through no fault of defendant who gets called in, correct?
I'm sorry, I didn't hear that.
The violation is no fault of the person who is out on the monitor.
The monitors cease to be paid for.
Right, so that's no fault of the person.
I guess that's up to your own view of the situation.
Okay. I hope I made a little sense there. Thank you.
Thank you. I've got a few more here on the list.
Mr. Chairman, if I may, and I apologize, I had several conversations before committee started and had my vote count locked up, but it took longer than I thought. So I apologize to Leader Lamberth and others who had bills after me. So I move that we roll this to the heel of the calendar.
Okay. All right, without objection, we will roll 217 to the hill of today's calendar. All right, we are now moving, members, on your calendar to House Bill 55. House Bill 55 by Leader Lamberth. We have a motion and a second. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. I know it's getting late. Representative Garrett stands here as a co-sponsor with me. This bill passed this committee last year and was doing very well. It's the Spencer-Bristol Act. And on December the 30th of 2019, MPO Bristol was chasing a fleeing felon and was struck and killed. He was doing his job, and this is the Spencer-Bristol Act. It's named after him, his wife Lauren, and their little girl. It means a lot to them that this bill is named after him. And what this would do would increase the penalty if an officer is pursuing a fleeing felon, a fleeing subject, and they are killed due to that evasion. That's what the bill does. I stand ready for questions, Mr. Chairman.
Thank you. Any questions for the sponsor? Question has been called. Without objection, we are now voting on House Bill 55 to send it to full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. Move on to full criminal. Thank you, sir.
Thank you, Mr. Chairman and members of the committee.
Okay, now we are going back to House Bill, item number 19, House Bill 786 on your calendar by Leader Lamberth. We have a motion and a second. Leader Lamberth, you are recognized on this.
Thank you, Mr. Chairman. And, Mr. Chairman, would you prefer, I know this may be a relatively lengthy bill, would you prefer I present from the podium or go back to my seat?
If you don't mind, present where you are there, and we're going to have, this is where we're going to have some testimony here in just a few minutes. So if you'll give us an introduction, then without objection, we'll go out of session and hear from our guest.
Yes, sir, and I know it's getting late, so I will keep this brief. This bill is very simple. There are two amendments. We can potentially take those up after the testimony. Mr. Chairman, I'm perfectly fine with that because I know these folks have waited a long time. But the two amendments, just so the members could be looking at it, are Amendment Code 3738 and 3979. And 3738 merely cleans up the first portion of this bill and makes this a very simple bill. We are taking a misdemeanor offense off of the books for law-abiding Tennesseans, law-abiding gun owners that lawfully can possess that gun and are lawfully where they're supposed to be. They have to be 21 and up. That's the current standard for the carry permit that they would otherwise be eligible for. But, and for veterans, there are some exceptions there where you can be 18 and up. But again, the amendment that you have before you would, again, if we have time to get to this, and I hope that we do after the testimony, that amendment would really clean up that first portion of the bill and make it a very clean, clear, constitutional carry bill so that there's no criminal penalty if you were otherwise eligible to get a permit and you're simply a law-abiding citizen that chose not to. I do not believe that you should go to jail for exercising your Second Amendment rights. However, for those folks that steal a gun, for those folks that are felons in possession of a gun, for those folks that are using guns in violent crime, the second portion of this bill that's outside of the two amendments I mentioned significantly increase the punishment for those ne'er-do-wells out there that would misuse their Second Amendment right and cause havoc throughout our communities. And one of the biggest increases that is in this bill is that if anyone in the state of Tennessee, if this bill were to pass, steals a firearm, it is a felony if this bill becomes law, and they will serve 180 days mandatory minimum in jail. If it ain't yours, don't touch it. Don't take it. And for God's sakes, don't go sell it to somebody who's going to kill somebody with it. That's what this bill does. We don't want anybody stealing a gun. And if they do, the word needs to go out far and wide that they are going to serve real time. That's how most of the weapons that you see used in violent crime are obtained, through a theft. So we're going to come down hard on those folks, but at the same time, we're going to take penalties off of law-abiding citizens who have done absolutely nothing wrong and are merely trying to exercise their Second Amendment rights. it says that their right to bear arms shall not be infringed, and later on, when we have an opportunity to debate this bill, I can go into that further, but that means a lot to me. I know it means a lot to y'all, and anytime we can increase liberty here in the great state of Tennessee, it's a good day here at the legislature. With that, Mr. Chairman, I know you have quite a few folks that want to testify on this bill, and again, there are 2 amendments, but we can wait on that until after the testimony. Thank you, Mr. Chairman.
Thank you very much. Without objection, we're going to go out of session. We're going to have our guest here. They're going to testify. I know that I told you earlier that 7 o'clock was our hard stop. I have negotiated with the clerk's office that we will be able to get through the testimony for this bill and one other if needed this evening. So we will have 4 minutes each on those that will testify. And so the first that we have on our list is with the Tennessee Sheriff's Association. If they're in here, Sheriff, I see him coming in. All right, if you would, sir, please come up to the desk here. There's a microphone. You can, if you will, introduce yourself, who you represent, yes, sir, and then you'll have 4 minutes to go over your testimony.
I'm Jeff Bledsoe, the Executive Director for the Tennessee Sheriff's Association. Sheriff Bonner was on his way here to be with us this evening, but there was appeared to be a fatal wreck on I-40, and he was unable to get here in time, so I'm kind of filling in for him. I sent the letter that would cover what he was here to testify on. Okay, ladies and gentlemen, thank you for this opportunity. And on behalf of the 95 sheriffs of the state of Tennessee, we strongly support the enhanced penalties of the House Bill 786. But we, after study, have looked at how this will affect the permit basis, and we have looked at the process that's been in effect for the last 25 years, and it will not allow us to determine whether you can lawfully carry or whether you're carrying unlawfully. We cannot use the criminal history records to determine if you're encountered by law enforcement to know if you're not allowed to possess that. We don't have access to the records for, say, if it's a domestic violence case or you're rendered as having mental health issues or a disability under the mental health guidelines. We would not be able to know that on the side of the road or at someone's residence or anywhere out in the public that we're encountering someone that is armed. And we strongly support Second Amendment rights and those basic values. But we've been on record since last year of some requirements that we'd asked for it to be in place for this, and that's to maintain a method for us to verify that it's a lawful carry, whether it's changed worded as a permit or not, and to have implied consent that if you're carrying, we can verify that you're lawful, retain training required to be concealed, and give exemption to an agency that offers that training. And that pretty well covers the letter that I shared with each of you.
Thank you very much. Are there any questions for our guest here? We have Representative Beck.
Thank you, Mr. Chairman. I was interested in your testimony. Thank you for being here, by the way. But if you approach somebody and this was the law, you would have no idea if they had a mental health issue? Are they lost their right to carry because of mental health issues?
Under the current process, that is determined upon when a person is issued a permit. And if that permit is changed where there's no permit in Tennessee, that would not catch that. We would not know that on that encounter.
So our officers will be put in danger of confronting somebody with a mental health defect or someone who cannot buy a weapon for a mental health defect, but you, the officer on the scene, would not know that. Is that correct?
Yes, sir. We wouldn't know if they can lawfully carry, and we wouldn't know whether they're a threat or not at that time. But the deciding factor would be that if they aren't lawfully carrying, we can seize that weapon and take it and know from what we currently have that they cannot possess it due to that they do not meet the requirements of verification.
And is that the same with you? You testified as to if there was a domestic situation. Can you tell me what that's about?
Under a conviction with domestic violence, there are restrictions that are placed upon the handgun, and with the courts issuing those restrictions, or there may even be restrictions upon them being out on bail while they're dealing with that. So I don't know the specifics of it, but there are some guidelines that if you're convicted of a domestic violence in Tennessee, that has an impact upon your ability to carry. That's my understanding, sir.
So if this bill passes, we're putting our men and women on the front lines in danger of walking up to these people and having no idea if they can possess a gun or not. Is that, am I hearing that correctly?
I wouldn't say necessarily that it's a danger at that point. It depends on the behavior of the person and the interaction that we have. What we're trying to determine is whether that is a lawful right to possess it or not. And as I've included in my letter, you know, we uphold the Second Amendment and believe in that. We just would like to have some way to verify and know if a person does not meet that lawful right. And right now, this system we've had since 1996 is the only method that we have to distinguish that person's lawfully carrying.
Very good. Thank you.
Hey, thank you. Before I recognize anyone else, I will say, members, and I do apologize for this. I know we have a lot of questions for our guests, but we have several that are wanting to testify. So we'll continue this round of questioning here, but as we move forward with our speakers, our guests, we won't be asking any questions for that tonight. So I'm going to go to Leader Lamberth. He's next on the list.
Thank you, Mr. Chairman. I appreciate that. I'll reserve my questions very brief. Sheriff, thank you for everything that you do, and I know you're pinch hitting today, so I'll be easy here. I just wanted to clarify the system that you're talking about checking that checks for those that have been involuntarily admitted to a mental health institution. That system's not available to your officers when they stop someone and they lawfully have a gun in a car without a permit now. You can't check that system if they're in a car with a gun, correct?
Yes, sir, you're correct. There's no way that we can verify that.
And there's no way, and Mr. Chairman, may I go back and forth a little bit just for purposes of speed? Yes, sir. Thank you, Mr. Chairman. And there's no way when you go into a home and you're investigating an incident and they have a gun in their home and they don't have a permit, you actually can't check that system if you're coming into contact with someone in a home, right?
Correct.
And in fact, if you go into a boat or if you come into contact with somebody on a motorcycle or somebody that's lawfully in their business, I mean, none of those places, they're required to have a permit now, and you can't check that system now in any of those locations, correct?
Correct. On the mental health side, sir? Mm-hmm. Yes, sir.
Yes, sir, in the mental health. And in fact, would it be fair to say that in your officers' interactions with individuals, do they come into contact with more folks that are in a vehicle, business, home, boat, RV, all of these other locations combined, or do they come into contact with more folks there or just walking down the street?
Your first scenario, all the combined.
Yeah, and again, fair to say this bill here, and I know you've probably seen the amendments, just deals with those individuals that are outside of the areas I've described, like boat, business, car, RV, home, that type of stuff. We're just talking about folks that are going in between those particular areas or just walking down the street. Is that fair enough?
Yes, but it depends on our reason for that encounter, what law enforcement investigation we're conducting.
Mm-hmm. And there's nothing, if somebody has a permit and they develop a mental health issue after they've gotten that permit, other than the Department of Safety revoking that permit because somebody's made them aware of the fact somebody was involuntarily committed, there's no way for you to be able to check that if somebody, after they got their permit, developed a mental health issue other than regular investigation. Is that fair?
That's my understanding, yes, sir.
All right, and kind of last question here. Domestic violence, I mean, you're prohibited from having a gun, period, after being convicted of domestic violence. Doesn't matter if you have a permit or not, you're simply prohibited from having a gun, buying a gun, possessing a gun. Is that fair?
Yes, sir.
All right, thank you. And that's already in the code, and nothing in this bill changes that, right?
Not that I'm aware of. We just can only verify that through the permit now.
Well, sorry, Mr. Chairman, one other thing. not entirely. I mean, you do have access to the NCIC system, and if somebody's been convicted of a domestic assault, that would be on their criminal history, correct? Or should be?
Well, my understanding, and I may be wrong, is that NCIC will not allow us to use that for a mechanism to determine if you can legally carry. We have strict guidelines that now we have to have a case number and an investigation open before we can even run a criminal history.
Sorry, my question was, though, it would be on the NCIC if you have reason to access that, and it would be on their criminal history if they had a domestic assault.
Yes, with an investigation, yes, sir.
Yes, sir. Thank you. Those are my questions, Chairman. Thank you.
Thank you, Representative Griffey.
Thank you, Chairman. I'll be brief. Sheriff Bledsoe, thank you for being here, and thank you for your service to the safety of all Tennesseans. And I know every member of this committee is concerned about officer safety more than any other issue regarding this subject of this bill. My question is this: there are currently, I believe, 18 other states that have constitutional carry now, and it's my understanding a number of those states have had constitutional carry for a number of years now. And is it still your understanding, at least it's my understanding, that we tend to see a lot of gun violence and gun crime in some of those states with the most restrictive gun laws, such as Chicago, Illinois, New York, California, LA, and so forth. Has the Tennessee Sheriff's Association had any communication with any of these jurisdictions where constitutional carry has been enacted to talk with those organizations whether they've experienced significant problems after the passage of constitutional carry? Thank you, Mr. Chairman.
I have not, sir. I haven't talked to any of my colleagues across the states. I've just done some research online and what variables have had an impact on it.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman. Good evening to you, sir.
Good evening.
So that I'm clear on this, you're not in support of the bill?
Not as written. Our sheriffs are opposing it as written.
Okay. And I think the way that you present it, you've said that when you encounter a citizen with a gun today on the current statute, the way you verify whether that's a qualified gun owner and carrier is through checking the permit system.
Yes, sir.
All right. And if you don't have the permit system, how will you know, if this bill passes, how will you know whether that is a upstanding citizen or a criminal who does not have the right to bear that arm?
It will make it difficult. That's the only method we have now for that verification is the permit side of it.
All right, so currently, if you check and you find that there is no permit and the citizen is unlawfully carrying the weapon, then you are forewarned and you're able to conduct the relationship between the law enforcement officer and the citizen. You're able to conduct your business as if you have someone who has violated the law and you have identified them as such.
Yes, sir. It allows us to go further investigating.
If I'm a criminal and have a weapon on me, and you ask me, that if this bill passes, and you ask me if I should, if I'm qualified to carry that weapon, and I say, yes, I am, what further investigation can you do at that point?
It would be limited, specific to the carry of the weapon, the handgun, unless there were other factors of our law enforcement involvement or an open investigation that we're conducting where we could start looking at criminal histories or things that would be allowed. But under just that encounter of talking to you, we wouldn't have a mechanism or method that tells us that you were a convicted felon and not allowed to possess that.
So I could be a terrorist, I could be a domestic violence offender, I could be nutty as fruitcake, and there's no way for you to know because you're putting me on the honor system.
Correct, unless I've dealt with you before or know you through other encounters. You're correct, sir.
Okay. Thank you. Thank
Yes,
you, Mr.
sir.
Chairman.
Thank you, Representative Russell.
Thank you, Mr. Chairman, and thank you for being here today. How do you currently determine if a person can lawfully carry a weapon?
We use the state's permit system, which just verifies that they've checked all of the requirements of the statute and lets us know that they haven't had a disqualifier or something that would prevent them from possessing that and carrying it publicly.
And when you check that, could you walk us step by step? Do you call it in on radio or phone, or how do you check that permit to make sure it's valid?
Normally, we're out in the field, and that would use either the radio or phone through our dispatch centers, and that permit is attached through the state records and identified through the driver's license, whether or not they're a valid permit holder.
So you would, your deputies would contact a dispatch center, and the dispatch center would either run a number or name or somehow or another determine if that handgun permit is valid?
Yes, sir.
And I know this don't affect handguns, but this will go back to where I'm going with this. So how does your deputies check an order of protection if they answer a domestic call?
That is also a record that comes from the court that issues that protective order, and it goes to our dispatch center, and it's logged in through the database, and it allows us to know, or anyone else, that if they're out of state, it would even access the national system to say that that protective order's active.
And is that through TCIC or NCIC?
I know we enter our data through TCIC, but I haven't been hands-on with that in so many years, but we have the ability that it's run, you know, we occasionally find someone that has that in another state, so I'd assume it has the national tie.
And if you came across an individual with a gun and you had probable cause to believe that they shouldn't be carrying that weapon, could you run them through the TCIC to determine if they've had that privilege revoked?
I don't know the exact answer to that. I think we could run it through the state, but it would be limited on what that record would give us. And then depends on age and prior to when everyone had computers as to when those records started coming on the system.
But you would have to run it either way to determine if the handgun permit was valid.
Yes, sir.
And so if there's a way to contact dispatch for a handgun permit, there should be a way to contact dispatch for probable cause to determine if somebody's permit or rights have been revoked.
At this point, we don't have that system to tell us that it would be unlawful. We just go by who's lawfully carrying. I'm not sure I understood the question.
So I guess let me rephrase that. So if you had an individual that you thought that might be carrying a weapon illegally, if this bill passes into law and you think that that right that they have has been revoked, could you not call their name into dispatch with their birthday and check and see if that's been revoked?
If the permit was revoked, is that what you're asking?
No, if this bill passes into law, I'm sorry, I didn't make it clear. If this bill passes into law and we have a constitutional carry in Tennessee, and you see an individual carrying a weapon, and you think that person is carrying that weapon illegally, maybe they had an order of protection or something against them, could you not take their name and birthday and call that in just like you would if you entered a domestic call?
We can check the local state system, but it would be just confined to Tennessee is my understanding. I would rather yield that question to the next testimony from the state.
Okay, thank you.
Yes, sir.
All right, thank you. Next on my list is Vice Chairman Sexton.
Thank you, Chairman. I want to quote the Second Amendment to you in case that we forget this. It says, "A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed upon." So you are saying, and I appreciate all that our sheriffs do, but you're saying as a law enforcement agent that you want to infringe upon our rights by forcing us to go get a permit and pay for that when our Second Amendment says that we have the right and it shall not be infringed upon. Is that what you're saying?
No, sir.
What are you saying?
I'm saying we still need to, with this bill, look for a method that lets us know whether that person is unlawfully carrying.
So you're wanting to override the Second Amendment that says that it shall not be infringed upon. You're wanting to find out some kind of, you don't know if someone's going to rob a store. You don't know if someone's going to commit murder. There's no way for you to tell what a criminal is going to do, but yet you want to infringe upon the rights of us as a people and our Second Amendment rights to be able to freely have a gun, protect our family. You as a law enforcement officer, you can carry yours everywhere. But as an individual, as a citizen, you're wanting me to have to go and get a certificate. When our forefathers gave us the right to keep and bear arms and said that it shall not be infringed upon. And it said for the security of a free state. And I believe these kinds of laws are what's causing us to lose our freedom in America, and I certainly do not appreciate our law enforcement wanting to take away our guns. And I think that's what that you're trying to do. I wish that you would, and the Sheriff's Association would back off on this, because you're impeding on the rights of the citizens, the very ones that you say that you are trying to protect. I'm offended by the fact that you're doing this. And I say that you need to back off and let citizens be citizens and carry the rights that we have as Americans. We're losing them every day, and it's time for us to stand up and take them back. Thank you.
Thank you. That's all I have on the list. We have no further questions, so we thank you for your time and coming and testifying before us. And you may be excused. Next on our list, Mr. Ryan Flugar. If you would like to come up, introduce yourself, the organization you're with, and you will have 4 minutes for testimony. And just as a reminder, and again, I want to apologize, we are on time constraints. There will be no questions for the remainder of our guests for this evening.
Thank you, Mr. Chairman. Thank you, members. My name is Ryan Flugar. I'm the Vice President.
Mr. Flugar, would you please turn your mic on? There's a button right there. Thank you.
Mr. Chairman, members, my name is Ryan Flugar. I'm Vice President for the National Association for Gun Rights. The bill as written that's before us is, I believe, language derived from the governor. And previously, I've testified against that last year because we didn't believe it went far enough. We didn't believe that it was a true constitutional carry. I understand that there are 2 pending amendments. I'm not familiar with the second one, but the first pending amendment, if I may speak to that, we believe that takes us in the right step. It's a step in the right direction. And if the bill were to pass as amended with that First Amendment, we would be in support of the bill. However, it's not the cleanest version that we've seen. The cleanest version that we've seen is actually Representative Griffey's bill, which I believe we may hear later today. Our issues with the bill as amended here is that it doesn't guarantee the constitutional carry for individuals who are law-abiding adults age 18 to 20. It does for military personnel, but it doesn't do it for, say, the single mother who wants to protect her kids while she goes out to the grocery store or to a restaurant. We believe that this bill would be much stronger if it included all law-abiding adults. For comparison, there are 18 constitutional carry states now, with Utah and Montana just being added to that list last week. 10 of those set constitutional carry at age 18. Only 8 of them set it at 21. So we think it would be best if it went back down to 18. Second, the bill that is before us uses the term handgun, not firearm. And we believe that that's a limiting factor. It could put law enforcement in the position of having to guess which firearms are considered handgun under state law. Those are the 2 main objections that we have. That being said, if this bill were to pass as amended with the language that I've seen, that would put Tennessee as the 19th constitutional carry state. It would just be in one of the bottom tiers of that 19. So we would still support the bill, But we think it could be better, and we'd actually prefer Representative Griffey's bill.
Okay, thank you. You had a minute left, but if you're through, we'll go ahead and stop there. And so thank you. Next up on our list, we have Mr. Jimmy Music from the Tennessee Bureau of Investigation. If you would, state your name and identify the organization that you represent, and then you'll have 4 minutes for testimony.
Thank you, Chairman, committee members, good evening. Jimmy Music, Tennessee Bureau of Investigation. I think I sat here about this time last year in this same room on this same issue, and the comments that I have will be generally the same. And I think the sheriff hit on some of those. Obviously, we support the underlying premise of people being able to legally possess and protect themselves with a firearm. The key there for us is to understand and have the ability to make sure they're actually legal. To really do that, and I think some of that was alluded to earlier, there are places, and I sent an outline to the chairman listing the things that are in the NICS index. So those indices are what is checked when you either attempt to purchase or purchase from a federally licensed firearm dealer, or when you get your carry permit. And so within those, I listed the places where the same information may also exist so that it's clear about what is and isn't there. And I think what's important here is that, and I will just tell you, there are 23 million records in those indices nationwide. Those are going to be records that indicate someone is prohibited, and we don't set the rules of how you can access that or not. The federal government does, and you're limited to be able to check that either at the purchase or for the carry permit. And so, because of that, I think that's what that Sheriff Bledsoe is alluding to, is that it's going to be very difficult for an officer on patrol to know whether that person is truly legal or not. Now, if the information is contained in NCIC or the III, then they may very well be able to. There is one category that is almost exclusively in NICS, and that's going to be those mental defective entries. We have about 63,000 entries in Tennessee, and those are going to be orders that you get in there by either being not guilty by reason of insanity or been determined incompetent to stand trial, you've been involuntarily committed, you're a danger to yourselves or other, you lack the capacity or contract and manage your affairs. Those are all going to be judicial determinations. You had a due process hearing before it goes into place. So with that, for us, there has to be a way to do it, and to check it and ensure that you're legal. And we have asked the federal government if they would allow us to use these indices for routine things like encounters or investigations, and they've said no. So for those reasons, those are our concerns of why we have issues with your bill. I'm sorry.
Okay, thank you very much. Thank you for your testimony. And as a reminder to all the members on the committee, all the information that these presenters have been emailed to you. You will get that each week as we have folks that wish to present. Next on our list is a Stryker Warren Jr. If you would come forward and identify yourself, and you'll have 4 minutes for your testimony.
Mr. Chairman, committee members, my name is Stryker Warren. I'm a Davidson County resident. I'm a Republican and I love this state, but I'm here tonight to represent over 100 businessmen and businesswomen in the state who vehemently oppose this bill. A bit of background, I grew up in rural Northern California, a town of 700 that was a logging town. I took gun safety classes when I was 12 and began to deer hunt and bird hunt. 2 of the 6 firearms that I own today, I bought when I was 12 years old. I began to read Shooter's Bible as a 7th grader, knew all the ballistics tables by memory, and learned how to hand load. I know guns, and I respect guns, and I respect the Second Amendment. I'll also share an observation, having hunted with 2 previous governors of the state of Tennessee and 1 U.S. Senator. Not one of those would support this bill. Let me synopsize my written testimony that I've turned in. When I look at this, the first thing that I would call to your attention is that citizens polled in the state of Tennessee, 90% of them, your constituents, oppose this bill. Chiefs of police across the state have opposed this bill, your law enforcement leadership. I cannot imagine how this helps with economic development and recruiting the Fortune 500 to Tennessee. This is certainly not a cornerstone to any foundation that helps with that kind of recruitment. I'm convinced there'll be more guns in cars, a problem we already have now with theft from cars. And increasing the penalty for stealing a gun hardly justifies the passage of this bill. In business, it's our responsibility to solve problems. This bill does nothing to solve any problem I'm aware of, and in fact, it creates problems. Please separate the signal from the noise. Thank you very much, Mr. Chairman.
Thank you, Mr. Warren, for your testimony. Next up, we have Mr. John Harris. If you would come forward and introduce yourself, your organization, and then you'll have 4 minutes to present a statement.
Red light, green light.
Red light.
Okay, very good, thank you. Mr. Chairman and members of the committee, I'm John Harris. I'm an attorney in Nashville, Tennessee. Been practicing 36 years. For the last 27 years, I have served in a volunteer capacity as the executive director for the Tennessee Firearms Association. I've been coming to this General Assembly since 1995 on firearms-related legislation. When I first came here, I dealt with Chairman Frank Buck in the judiciary. Some of you may recall him, and he was a great guy, and we had a lot of conversations about the first permitting bills. And in those conversations, we often talked about Vermont-style carry. And that was because the state of Vermont, since it was formed as a state in the 1700s, has had in its constitution that citizens 18 years old and up can carry a firearm, no permits required. It has been a success. But from the 1700s until 1995, it was the only state that had that in its law. Again, it was called Vermont carry. Since 1995 through today, we now have 18 states that have adopted constitutional carry, which is now the more common term to describe permitless carry. It is, in our definition, TFA's definition, a process or a law whereby any legal possessor can carry any legal firearm. That typically would mean 18 years old and up. It would include rifles, shotguns, and pistols, not just handguns. And that's how we classify constitutional carry as a state organization. As indicated by the spokesperson from NAGAR, of the 18 states that have constitutional carry presently, most of them grant that right to 18-year-olds. Tennessee, in fact, has had for the last 7 years a subset of constitutional carry that's found in 3917, 1307 subpart E. You might know it as vehicle transport, but it is pure constitutional carry. Anyone who can legally possess, 18 and up, can have any firearm they can legally possess in their personal motor vehicle. We've had that for 7 years. It has not been a massive problem in the state of Tennessee for law enforcement, for anyone else. That is what TFA is asking you to bring forward out of this committee this year. True constitutional carry, 18 and up, any legal firearm. That gets us where we need to be. That puts us in the trend that other states are going. And that's generally what's outlined in the letter that I submitted in writing. Now, I would say that it's worth noting that there's frequently a lot of opposition, as you've already heard tonight, to constitutional carry or permitless carry. But the fact is, of the 18 states that have adopted it, not a single one of them has repealed it. None of them have gone back and said, now we need to put additional burdens, restrictions, or hurdles in front of citizens who want to carry firearms. They have found this to be a success, and I will tell you this, if it was not a success, you would have other speakers, those coming forward on this bill and on Representative Griffey's bill, showing you data, not opinions, but data from other states where it's been a failure. That data doesn't exist. If you pass this law, you will be moving Tennessee forward towards constitutional carry and away towards systems where states in the past did not trust their citizens with fundamental constitutionally protected rights. Thank you for letting me speak to the committee.
Thank you very much. Next on our list is Matt Harriman. If you would come forward, introduce yourself and your organization. You'll have 4 minutes.
Okay. Thank you, Mr. Chairman and committee. For the record, my name is Matt Harriman, and I'm the Tennessee State Director for the National Rifle Association. I want to thank you for the opportunity to address each one of you on this issue, which is very important to NRA members and gun owners throughout this state. On behalf of our members, I want to publicly thank Governor Lee, along with Senate and House leadership, for their support of this effort and for including the NRA in this process. This is an effort that the NRA has led the fight on across this country, including the recent successful efforts in Montana and Utah. We are in strong support of House Bill 786. My goal today is to provide you with some facts around permitless carry from other states that have opted for this policy. Additionally, I hope to dispel a few of the myths and the misinformation that is circulating around this issue. The first thing is that this is not a new or uncommon policy. Nearly 2/3 of U.S. states allow for permitless open carry, putting Tennessee actually in the minority of states that does not allow for any form of permitless carry. In most of the country, law-abiding citizens can carry a firearm for self-protection purposes without the government's permission and without having to pay a fee. Our current system is set up as a privilege and not a right. Secondly, permitless carry will not allow prohibited persons to carry or buy guns. This legislation does not change prohibited person laws or any law governing the misuse of a firearm. In fact, as Leader Lamberth pointed out in his opening, this bill greatly stiffens the penalties for those criminals who choose to commit crime involving a firearm. Furthermore, it does not affect prohibited places or when force may be used in instances of self-defense. Felons, violent criminals, drug users, and those adjudicated mentally defective still cannot go into a store and purchase a firearm. The third thing is this states enacting this legislation do not devolve into the wild, wild west as some would have you believe. Opponents in every state claim that permitless carry is once enacted, is going to be the end of days and of lawlessness. The claims are simply not true. Just look at the other 18 states that have this policy in place. People still apply for and pay for permits. The evidence from states who have enacted this policy have actually seen an increase over time in their permits. The reason for this is that people still want permits for reciprocity purposes for traveling to other states. The fifth thing here is criminals already carry concealed firearms without regard for the law. This legislation is not for them. It simply puts law-abiding Tennesseans on equal footing. Finally, as I previously mentioned, this legislation contains stiff penalties for those criminals who choose to unlawfully possess or steal a firearm. These are the people we need to target, not law-abiding citizens of this state. In closing, Mr. Chairman and committee, the Second Amendment is very clear and concise, and guarantees the freedom and the right to bear arms. It's time that we get back to a place in this state where we trust the citizens with the rights that have been guaranteed to them through the Second Amendment. With that, I thank you, Mr. Chairman and committee, and ask for the passage of this legislation.
Okay, thank you very much on that. Leader Lambert.
Thank you, Mr. Chairman. Just really more of a personal order. I wanted to thank Mr. Harriman and the NRA and several of the groups that have testified today for working on this, but specifically for Mr. Harriman. I mean, for the better part of the last year, he's been working on this legislation and working diligently on it. And so, Mr. Harriman, thank you so very much, and thank you to the NRA for standing strong, and thank you for all those that testified today, especially those in favor of the bill. But I wanted to thank you specifically because I know you have put in literally hundreds of hours on this bill and will continue to. And so thank you for your testimony, and wanted to say thank you for your friendship.
Okay, thank you to all those that testified. We're going to go back in session. We're back on House Bill 786. Without objection, I am going to roll this to the heel of today's calendar. Without objection, this will be rolled. Oh, wait. Leader Lambert.
Mr. Chairman, no objection. Would it be rolled? I know there's another bill on the calendar today that is a very similar topic, and it's by another member. Would it be rolled merely just so that member's bill could be presented as well?
That is correct. We're about to take that member's bill up as well.
Yes, and Mr. Chairman, I was able to present mine. I want to make sure he's able to present his.
Yes.
I'm perfectly fine with that, but at some point, I hope we do vote on this, but I want to make sure his is presented as well. Thank you, Mr. Chairman. Sorry.
Okay. Thank you. Without objection, we're going to roll this to the heel of today's calendar. Next item that we're going to take up is item number 23, House Bill 0018 by Representative Griffey. We'll need a motion and a second on that. Properly motion and second. Representative Griffey, you're recognized. If you will, give an introduction of your bill, and then we'll go out of session for those that want to speak on behalf of that.
Thank you very much, Mr. Chairman, members of the committee. House Bill 18 is constitutional carry. It essentially applies for all firearms, and individuals who are 18, who are legally can possess a firearm, 18 years or age or older in the state of Tennessee. I'm happy to answer any questions. And I want to, again, thank Leader Lambert for his kindness for letting me present mine, and we'll roll it to the hill and pick it up next week. And I also want to thank all the speakers and this committee for listening carefully and considering what I think is an important legislation for the General Assembly this year.
All right. Thank you, Representative Griffey. We'll go out of session. We'll have Mr. Ryan Flugar come back up. He wants to speak and has graciously agreed to 2 minutes for us here. If you will, again, just introduce yourself and who you're with, and then you may proceed.
Red button, there we go. Ryan Flugar again with the National Association for Gun Rights, here to speak in favor of Representative Griffey's bill, House Bill 18. This bill addresses a lot of the issues I mentioned when I was previously up here. We believe it's a true constitutional carry bill that simply states if you're legally allowed to possess a firearm, you should be allowed to carry that concealed with, or in this case openly, without having to get a government permission slip. So we support it. Hope you vote for it.
Okay. Well, thank you very much. That's all that have asked to speak on that. We'll go back in session. Representative Griffey, you're recognized.
Mr. Chairman, may I proceed from up here at this point?
You may, yes, sir.
Okay. I would just move that we roll this to the hill and pick it up next week when we take up both matters next week.
Without objection, we'll roll to the hill of today's calendar. Members, we have overshot our time here by quite a bit, and I want to apologize to each and every one of you. I know I told you we'd be out by 7, but we will here in a moment entertain a motion to adjourn. Representative Hardaway, you have a question.
Yeah, Mr. Chairman, I've got a bill that, for the sake of scheduling with the family that's associated with the bill, if I could get that bill heard and amended and put on next week's full committee, it would help me tremendously in working with the family. It shouldn't take but a minute. It's item number 24.
Okay, stand by just for a moment there, Representative. Okay, we will pick up, members, at item number 24, House Bill 0012 by Representative Hardaway. There's a motion and a second. There is an amendment that goes on to this bill, 003893.
Motion on the amendment.
Second on the amendment. Would you sponsor the amendment? Let us know what it does.
Chairman Curcio could be recognized for that, Mr. Chairman. Mr. Chairman, I'm late and I'm just jerking your chain. Chairman Curcio has left the committee at the moment.
Right.
I'll be happy to explain what it does.
Okay.
It deletes the last section. I'm sorry, Mr. Chairman, I couldn't resist. So it deletes the last section of this bill. The last section, I know the sponsor of the bill's heart has been to really upgrade and update our monitoring laws in this state for many years, and there are some bills that will do that, and many of those I have supported and will continue to support. In this particular bill, the last section, this amendment would delete that last section and keep this bill really just what the first portion does on abuse of a corpse. And I've signed on to this bill, fully support it. I do think this will strengthen the sponsor's bill and allow us to really deal with the monitoring portion of the bill in a separate piece of legislation. That's the reason why I think Chairman Curcio had filed the amendment, and I'm more than happy to have moved the amendment for consideration.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman, and I'd consider that to be a friendly amendment. I do have another bill, 1323, for those who are concerned about where that language is going. It will be combined with House Bill 1323, but for the sake of keeping this as a clean bill, have we already put that amendment on, Mr. Chairman?
We will here in just a few minutes.
I would ask that
Question
you
has been called.
favor the amendment.
On the amendment, question has been called on the amendment. All those in favor of adding amendment number 003893 to House Bill 0012, say aye. Aye. Those opposed, no. The ayes have it. We are on House Bill 12 as amended by Representative Hardaway.
Thank you, Mr. Chairman. I would ask for a favorable consideration of the bill as
Okay.
amended.
Thank you very much. Question has been called. All those in favor of sending House Bill 12 into full criminal, say aye. Aye. Those opposed, no. The ayes have it. Congratulations. You move on to full committee.
Thank you, Mr. Chairman, and thank you to the mysterious Curcio.
Okay, members, we're going to take up one more bill before we dismiss for the night. One more bill. Just one more. We'll have to get you next week. Okay, we're going to look at item number 14, House Bill 176 by Representative Russell. We have a motion and a second.
Thank
You're
you, Mr.
recognized.
Thank you, Mr. Chairman. What House Bill 176 does is prohibits registered sex offenders from participating in activities associated with Halloween. It also establishes a curfew for registered sex offenders from 6 p.m. on October the 31st until 4 a.m. on November the 1st.
Question's been, well, Representative Griffey has a question.
One quick question. Is this, the restrictions going to apply prospectively on people who are convicted from the point of passage forward, or is it going to try to apply to folks that are current sex offender registered?
Current sex offenders and anybody going forward.
I just, the reason I bring that up, I thought we'd run into some litigation of that in the past, and I just bring that up for committee's consideration.
Leader Lamers.
I support the bill fully, though.
Leader Lamers.
Thank you.
Thank you, Mr. Chairman. And to my friend's comment, there has been litigation, and there is constant litigation. It's amazing how litigious some of these sex offenders can be because they don't want to abide by the sex offender registry. And if they are dressing up and enticing children to their house, I think from a matter of policy, and I join you in support of the bill, that should be prohibited, period. Whether they were convicted 20 years ago, 2 years ago, or 2 years from now, no sex offender that is on that registry, the violent sex offender registry, should ever be allowed to do this, and it's an administrative finding. You don't have a constitutional right to dress up for Halloween. That's just not something I think that you have. If some court out there is curious as to what our legislative intent is, it is to protect children from dangerous sex offenders. And so I want to make it loud and clear to any court that might look at this, that's the intention of the bill. And nobody has a constitutional right to dress up for Halloween, but those children absolutely have a constitutional right to not be molested by some sex offender.
Thank you, Representative Beck.
Yes, Chairman Russell, they do this already in parole, is my understanding, for offenders that are out on parole. So you're just extending it to be for all sexual offenders that are on the registry. Is that a fair assumption?
That is correct. Parole was already doing it, and this just makes it into statute.
Very good. Thank you.
Thank you.
Okay, any further questions? If not, question has been called. Without objection, we're now voting on House Bill 176. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Go on to full committee. Now, members, that is our final bill for the evening. We will, all bills that were on the calendar tonight, we will take up this calendar again. We will start with this on the next committee date next Wednesday at 5 p.m. And all bills will be rolled to the next calendar. Do I have a motion to adjourn? Motion to adjourn. We stand adjourned.